Why did you buy the Patriot defense rounds?
Where are the, oh, those are that's the ammo? That was the ones my son told me to purchase. I didn't know anything about it. I'd asked him and he told me to purchase them.
So you told the jury yesterday, I think you repeated it again today, that the gift was for target shooting only.
Correct.
Okay. Yet you bought 100 rounds of ammunition.
Correct.
And you only shot 50 while you were there.
Correct.
Okay. And those 50, at least according to some statements you made throughout the investigation, you put somewhere.
The box of them, yes, I did. I hid them.
Now, on November the 27th, when you came home, you posted pictures of the gun and targets to your Instagram account.
Correct.
And then according to the location data, your location data, you left.
I think this only went, oh, I don't know. I must have, yeah.
Okay, well, you don't deny that.
I don't deny it.
And your husband James was gone all day, according to his location data.
I think so, yeah.
Okay. And you saw in the evidence that in the picture you posted, there's an ATF pamphlet on handgun safety for children.
Correct.
Did you read that?
I looked it over, correct.
On Exhibit 74 here, I'm going to get back to this meeting first. Exhibit 74, you don't deny that you could have left work for the day.
No, I don't deny that.
Okay. And you don't deny that you didn't tell the school officials, Mr. Hopkins and EJAC, about the gun purchase on the 26th?
No, we had stated that we went to the shooting range. I went to the shooting range with my son on Saturday.
You didn't tell them that you had gotten him that Christmas gift?
I didn't think it was relevant, no.
You acknowledge that you never told Mr. Hopkins and EJAC that it wasn't just a friend, but it was the only peer that you had ever met that left?
I had probably said his best friend.
You acknowledge that you didn't go home to look for that firearm after the meeting at the school?
We wouldn't have a reason to.
So that the answer is then you acknowledge that?
No, I acknowledge that.
Okay. And you acknowledge that you had already made plans for the night to go to the barn?
Yes, I do.
Okay. And you acknowledge that you had the time to stop at your house before you went back to work?
I would have, but I didn't have a reason to.
Now, you had told us that you had never taken your son to any sort of mental health professional.
No.
Okay. But you know how to obtain help.
Correct.
In fact, you have prescriptions related to that.
I do.
So it's not that you didn't know who to call or how to call, you didn't.
Correct.
Correct, okay. Yesterday you talked a little bit about how you express emotion.
Correct.
And in fact, I think counsel asked you about your nerves when you testified. But you're capable of emotion.
Yes, I am.
Right, okay. And in fact, you had some explosive emotional fights with your husband.
What we did.
And that was in the home that you shared.
Correct.
Okay. And with your son.
Correct.
We saw pictures of that home.
Correct.
And you told us that your son was at an age where he wouldn't text you back, I love you.
It wasn't a text me back, I love you. It's like in passing, like, hey, Ethan, good night, I love you.
Well, yesterday you told us that your son was at the age where he wouldn't text you back, I love you. Those were your words yesterday.
Yeah, but more or less like just saying it in passing. He wouldn't say it back. I said, good night, Ethan, love you, and he'd be good night.
Okay.
For him to text me that he loved me was abnormal.
Abnormal.
Correct.
Okay. But you didn't respond to that text until 44 minutes later?
No, I was in a meeting at work.
Okay. And if you go through your entire text message thread between you two, the word love pops up how many times do you think?
Between me and my son?
Yeah.
I have no idea.
Okay. 3.
Okay.
The first is in reference to the game chess about a year before.
Okay.
And the other 2 times are right before your son committed this act and after the shooting when you responded. Does that surprise you?
No.
Your Honor, I would just ask if there could be a foundation for the dates of those texts, because I feel like you got just a few texts.
Okay, well, I think he specified. Did you specify the date?
I did.
2 of the times were before and after the shooting, and the other time was when?
About a year prior. I could pull the data, if council would like it.
And I'm also wondering if what the data he's relying on is coming from Jennifer's phone where she deletes all her texts, or if it's coming from the shooter's phone. Because the prosecution's asking questions, I just want to know the foundation.
Oh, sure, let me clear that one up. It's from your son's phone, so all the messages would be contained there. You don't deny that information would be accurate.
No, I don't deny it.
Okay. Now,
What time period?
you told us that,
She said, he asked if the chess one was a year earlier, and the other two were close in time to the shooting.
the day of the shooting.
Yeah, I know.
I'm asking,
Those have been admitted in evidence.
do we know,
Wait, what's the question?
okay, but he's asking about the text overall, which have not been admitted into evidence, and I don't know that the text chain has all the texts. There's no foundation that what Mr. Keese is looking at.
Judge, in cross-examination,
is all the texts.
if
He's asked if that, is that wrong? Would you argue with that? That's what he's asking. I mean, there are people,
I know, she just doesn't know what.
hold on,
okay.
counsel can't
Okay.
testify.
no, she can't testify. Well, there are people that end every conversation with love you.
Yeah,
right?
I'm with that.
Okay, so, and there are people who don't, right? So he is asking what's normal for them, and would she be surprised that how many times that appeared?
Yeah, I'm
She
just
said she
asking, I get that, and I get that it's not common, I'm just asking. what
Judge, this is
period-
argument,
I'm just
counsel can
asking
argue
what
whatever she wants to.
period of
What's her-
text this is
What
from.
you have redirect. too.
Okay, well,
Right.
she doesn't know what he's even basing these questions on, is my
How,
point.
okay,
Well,
it is inappropriate for counsel to
Okay, she can
suggest
say, "I
or
don't know."
she or does not know.
She can say, I don't know, or she can also say, I don't understand the question. She can say that too. Mrs. Crumbley, if you don't understand the question, ask Mr. Keese to clarify it, all
Okay.
right?
All right, thank you, Judge. Yesterday, Mrs. Crumbley, you talked about going into planning mode.
Yes.
Okay. And that was in reference to counsel asking you about emotions and how you express emotions.
Correct.
All right. So I want to talk to you about planning mode and your priorities from the time that you were arrested.
Okay.
Now, your phone calls were recorded from the time that you were arrested until now. Do you know
Correct.
that? You know that, right?
I knew that.
You know that, okay. And your priority on your first phone call, December the 4th of 2021, was on your animals and the cash recovered from the art studio. Do you deny that?
I don't deny it.
Do you deny that it wasn't until 10 days later and 14 calls later that you even mentioned your son? Do you deny it or not?
I don't, but I was under the impression that I couldn't mention him because I could get flagged at the jail.
Well, you mentioned him in later conversations,
I did.
okay? And in fact, in one, a year later, March 25th of 2023, you said he just needs to man up. Do you recall
I
that?
do not.
Okay, do you deny that you said it?
It sounds like something I would say.
In December of 2021, your concern was about a GoFundMe. Do you remember that?
No, I do not.
I'm going to play this for you. Ms. Williams, can you have the volume up, please?
Is this submitted as an exhibit?
This is impeachment, Judge.
Okay, you're not asking for it to be.
So,
And you're about to GoFundMe to help like pay for my work work.
well, there's no, Jennifer, that's,
I just mean like you know kind of particular things, but I know there's a lot of people that call the lawyer asking about the welfare of my horses. So I mean, listen, I'm throwing shit against the wall to see what's fixed.
what's that?
I'm just throwing shit against the wall to see
Oh,
what's
I know.
Okay, that was between you and your dad,
Correct.
okay? And you asked him to set up a GoFundMe to pay for the board of your horses?
I did, yes.
Okay. You were concerned about other things related to yourself around that time, weren't you? Is
Yes,
this still planning mode?
I believe so.
Okay. And you were arrested December the 4th. This is going to be December the 22nd.
could have found it for now.
Yeah, okay.
Can you have her Google how many calories are in a bologna sandwich with white bread?
How many calories in the bologna sandwich with white bread?
Yeah, American cheese.
And what with American cheese?
Yeah.
You got some mayonnaise on it?
No, just mustard. No, there's not any mustard. And then peanut butter and jelly. I like bread.
And peanut butter and jelly like that. Okay, so he's looking up bologna right now. Is that what your lunch and dinner is?
For the most part, yeah, and the other stuff, my cereal now comes in an actual container.
American cheese, yeah, American cheese.
And an apple and a banana. Because they
Okay.
they're carb loading to me, and I want to make sure I stay at like 1,000 to 1,200 calories.
No, I know banana's 100 calories.
And then, okay, what about apple?
Yeah. So the sandwich is 140 calories. Oh, 240.
Okay, I guess 300 is a good indication.
Yeah.
Calories with it.
And then peanut butter and jelly and white bread.
Yeah.
Still planning mode?
Well, I wasn't planning there, no.
Okay, now we're talking about how you describe planning mode. You describe that in context to statements you made to the police on November the 30th, 2021. Right? That's the context you use the words planning mode in relation to.
Correct.
Okay. So you told us that the last phone call on December 31st, that was still you in planning mode. I want to make sure we get an accurate depiction of what that is. Now here's one from January 15th, 2022.
No, it's not an issue of that, it's an issue of, that bank seems to be always, they've had issues with their online stuff, and they had issues with, just all kinds of stuff. I go, geez, how can they like bank with these people, it's like, so, but.
This was that child deposit thing.
The what?
Am I supposed to get a deposit of $300 that child thing the government does?
I just got, because I lost access. For some reason, I'm not supposed to, but
Yeah.
I had access, I had access basically to view only. And it was hard to see everything on there, but then also I lost access, and then it took me, I lost access like a couple days before Christmas.
Yeah.
Okay.
Okay. Is that still planning mode?
We were talking about filing my taxes if you played the whole thing.
So you were asking about your child tax credit.
Correct.
You're still gonna get that $300.
My dad was doing my income taxes for me.
Now, when we started, we confirmed that you understood the oath that you just took,
Correct,
and the same oath you took yesterday.
correct,
Okay. And you don't deny that you had $6,000 in cash in your purse the night you were arrested.
no,
You don't deny that your purse with the cash and 4 cell phones were in a plastic tote.
correct,
You don't deny that that plastic tote was contained in a different plastic tote.
correct,
You don't deny that your backpack with clothing items was found in a different plastic tote in a different area of that studio.
correct,
Okay. And you don't deny that you knew you had been charged with involuntary manslaughter.
correct,
In fact, as early as December the 1st, 2021 at 6:10 p.m., you were talking about how you were being charged with involuntary manslaughter.
That was what I was being told by a family that was texting me. That's what the charges might be announced as, correct.
Okay, and one is to Mr. Malash. There's a text to your cousin about you are being charged with involuntary manslaughter. You don't deny receiving that.
No, I don't,
That's Wednesday, December the 1st,
correct,
right? And you sent your neighbor a message on Wednesday the 1st of 2021, 6:55 p.m. that you were reading, they may charge us,
correct,
okay? And December the 2nd, 2021, you wrote, they're saying involuntary manslaughter.
correct,
You don't deny that?
No.
And of course, you looked at different news articles about that the next day.
Yeah.
And later on that day. And then you texted, after all of these messages and news articles, December the 2nd, 2021 at 2 p.m., we're fucked. You wrote that to Mr. Moss.
Correct.
Okay. And then you wrote announcing charges at noon on December the 3rd, 2021 at 8:17 a.m.
Correct.
And you wrote that to Mr. Malash, you wrote that to Kira, you wrote that to your dad, right?
Correct.
Okay, so you don't deny any of that?
No.
Okay. Now you told us yesterday that you popped 4 Xanax?
I did.
Okay, and your husband popped 4 Xanax?
Correct.
You said you went to bed about 11 o'clock?
It was around that time.
Okay, and the evidence that we have admitted show that you set your alarm for 6:30 a.m. and 6:45 a.m.
I don't know if it was me who set it, but it was set for that time.
Okay, and from the evidence it shows when it was set too.
Correct.
Okay, and it was set a little after 11 p.m.
Okay, correct.
Yes? Okay. So, yesterday you said, I want to say it was after 11 about going to bed. I want to say it was after 11, maybe around 11 o'clock when we finally went to bed. I prescribed Xanax for anxiety, and we each took 4 because we knew we were going to turn ourselves in the next day, and we hadn't slept in 4 days, and we just wanted to sleep. The question was, okay, so you each took 4? Your answer, we did. The next question was, okay, so the next thing, the next piece of evidence we saw that was coming in that art studio, do you recall that? Your answer? I recall my husband screaming, there's people with guns against interface officers. Question, what were you doing prior to hearing your husband screaming? Answer, we were sleeping. Question, okay, were you aware that there was anything going on? Answer, I was not.
Correct.
That's your testimony.
Correct.
Okay. And you know when you say something that isn't true, that's called a lie.
Correct.
Okay. This is going to be exhibit 430. Council does have a copy.
Is it
The entire thread.
perfect? No
Here you
objection.
go.
Oh, thank you.
Judges, the court have a copy?
Is this today's?
Yes, Judge.
Okay. Any objection?
No,
Okay.
Mrs. Crumbley, you knew the police were there.
4:30 is admitted.
Thank you, Judge.
Not until I woke up, no.
Not until you woke up.
Correct.
Okay. Now, we heard testimony yesterday, or throughout the trial, that 911 was called at 10:43 p.m. You recall that?
Yeah, I saw in the video. Correct.
Okay, and on the video, the first officers arrived before 11 p.m.
Correct.
Okay? And either you or your husband, we couldn't tell from the video, but you tell me, was it you or your husband out there smoking?
That was my husband.
Okay, so your husband walks in shortly after the 911 caller walks in the building and call 911.
Correct.
That was on the video.
Correct.
Okay. And officers arrived. And then we've heard testimony from Mr. Kirtley, who had a studio there. We heard testimony from Sergeant Hendrick, who was in the fugitive apprehension team, as well as Corporal Shaw with the Detroit Police SWAT team about the amount of officers there. You recall that?
I do.
And you recall hearing the testimony that Corporal Shaw's team, their SWAT team, they actually used a 35-pound steel ram to bash in a door at the studio next to where you were at. You recall that testimony?
I do.
Okay. And your testimony was that you were asleep when the officers arrived.
Yes, I was.
Okay. But you had an alarm set for 6:30 in the morning on your phone, and that phone was found powered off, hidden in a tote, contained in a different tote, in a place away from the bed.
Correct.
You don't deny that?
No.
All right. And there are certain messages in 430. I'm going to go through them with you. This is actually to your attorneys. At the time, you had 2 attorneys. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. That's it. December the 3rd, 2021, 6:04 p.m. Did you recall that?
I don't, but I don't deny
You don't?
it.
Okay, you don't deny.
No.
Okay. Your next message, the other phone broke. That's December the 3rd, 2021 at 6:04 p.m. The response was, when you can, we would like for you to call us. That was from either Ms. Smith or, at the time, co-counsel Marielle Langdon.
Correct.
Your response, I'm sorry, this is from Marielle. Thank you. Shannon is calling you both shortly. At the top it says to and from. I'll make sure I identify for the record. From Shannon, Marielle and I are going to come get you guys in the morning. We do not think it will help to make a statement that you're coming back now or that it will be tomorrow a.m. We can say that we told everyone you were coming back, and as of tomorrow a.m., you are back. That's Friday, December 3rd, 2021, 7:02 p.m.
Correct.
Right? Okay. So that's after James had already moved the car around and backed into the parking spot.
I believe so.
All right. From Shannon, we can show them that everything we said was going to happen did happen. That's Friday, December 3rd, 2021 at 7:02 p.m. Right?
Right.
Your response, okay, that's at 7:03 p.m. From Shannon, I'm going to drive home from my office right now and call you guys in about 40 to 45 minutes so I can get all the bond factor information written down from Marielle and me. That's Friday, December 3rd at 7:36 p.m.
Correct.
Okay. Your response, okay, we'll be waiting, 7:37 p.m. Shannon, I'm going to call in 1 minute. That's at 8:54 p.m. that Friday night. Your response was okay. Do you recall?
I don't, but I don't deny it.
But you don't dispute the records.
Correct.
The next message you send was, think we might have found, don't know, just heads up, please check. December the 3rd, 2021, 11:14 p.m.
That was written, but I do not believe it was written by me.
Okay, you don't remember, well, you told us you don't remember any of these text messages. You just
Right,
specifically don't remember this
I
one?
read through it, but,
You don't deny that this was on your phone, what we refer to as the burner or track phone.
correct, we
You don't deny that.
were both using that phone at the time because my husband's broke.
Okay. And then you wrote in quick succession, don't know, 11:16 p.m. We might have been found, 11:16 p.m. Laying low, 11:16 p.m. You don't deny that these are the records?
No, I don't.
Okay. Response from Shannon, oh shit. Friday, December 3rd, 2021, 11:16 p.m. Now we know from all of the objective evidence, the testimony, the video, everything that the officers testified to, they were on scene before 11 p.m. You don't deny that?
No, I don't.
You don't deny that there were hundreds of officers on scene?
I don't know how many were on scene.
Okay. How many did you see when you got pulled out of the art studio?
Honestly, I don't know. It all happened so fast. I knew there was more. There was a few. There was more than a few, but not.
You saw the body camera footage.
Right.
Okay. I do want to make a point so everyone's aware. This exhibit was just made admissible this morning.
Correct.
Okay. So we actually just received it this morning, and when you testified yesterday, you didn't know this exhibit was going to come into evidence.
Correct.
Okay. I want to talk to you now about the night before the shoot. November the 29th, 2021. You had testified that you got into a fight about grades with your son.
Correct.
Okay. Is that because you checked Power School?
Yes.
Okay. During that fight, did you lock your son out of the house?
Did not.
You don't deny that he was outside of the house?
He did walk out of the house. He was upset.
Okay. You told us that you took his phone.
We did.
That's not true, is it?
That is true.
On
We took it.
November the 29th, 2021, your son filmed a 19-minute video while he was outside describing what he was going to do the next day.
What time was that taken?
10 o'clock.
I don't know if he got it back. I know we took the shooting range away and we took his gun away, so I don't know if he got it back.
Okay. Now, all of the times that you were at the barn, there was nothing stopping you other than you told us he didn't want to go, right?
Correct.
There's nothing stopping you on November the 30th, 2021 from taking him home.
Correct.
Nothing stopping you. No, actually, I want to go back to what you just said. You took his gun away.
We took the shooting range away.
You said you took his gun away.
No, I said we took the shooting range away.
Your son could have been with you those 3, 4, 5 times a week when you were at the bar.
He could have, yes.
Your son could have been with you on those times when you were with either Mr. Malash or somebody else.
No.
In the weeknights, he could have been with you after school, after work.
I wasn't with Mr. Malash at those times.
Okay, the other individuals then.
I wasn't with them either at those
Well,
times.
according to the
I
phone
might
finder,
have messaged people at those times, but I was not with anybody at those times.
he could have been with you on the Halloween party,
He did not want to go. It was a bunch of little kids.
and on November the 30th of 2021 at 12:51 p.m., you could have been with him,
I could have, yes.
and you didn't.
No.
Nothing further.
Redirect.
Thank you. Mrs. Crumbley, I just have two areas of questions for you. Mr. Keys played some recordings. Who were you on the phone with in those recordings?
And my dad.
Okay, so you asked a couple of questions about calories, and then what was the other one?
The child tax credit.
Okay, how often did you speak with your dad?
During the summer, it was every day. Then went back to work. It was just on the weekends. They're both teachers.
And how many hours a day do you spend with other people?
Sometimes it's none. Sometimes it's when they walk by my cell, I'll talk to them, but I'm locked down 23 hours a day. I get 1 hour out by myself. I talk to my clergy lady legally, so I see her. Sometimes I talk to the church priest, or I'll talk to my attorney, but that's about the most human contact I get.
So I guess one of my questions is, when you do talk to people, you talk about, are there more conversations than just those?
Right, there are.
Okay. And then that night on December 3rd, going into the 4th, after 11, there was one phone being used, is that right?
Correct.
Whose phone was being used?
It was my burner phone.
Who was using the phone?
My husband was using the phone.
Okay, were you also using it?
No, I was using my other phone. So he started using my burner phone. I used the one with our regular phone number to do anything on.
Okay, so these messages are from the burner phone
Correct.
to myself and Mario.
Correct.
So the ones after 11 o'clock, so at 11:17 or whenever these texts came in, what were you doing?
When I saw the video of my husband going to the car and having a cigarette, I knew I was probably sleeping at that time, because I did not like us not being together after what happened to us on the 30th when the police came to our house. So if he went out to have a cigarette, it was most likely because I was asleep.
Okay, when guns were in your face and we saw that on the video, before that, had you been asleep?
Yes,
Are you absolutely sure about that?
I'm positive.
Okay, I have no further questions, thank you.
I'm going to excuse you for about 10 minutes and let's see where we're headed. Okay?
All rise for the jury.
All right, you may be seated. You can rejoin your attorney. Okay, so tell me what's happening now.
Can I have just a moment with my client?
Sure.
Your Honor, at this time the defense rests and we're ready for closings.
Great.
We are not at this point. We would need at least a 30-minute. Counsel said she had 2 other witnesses today, but we can be ready in 30 minutes.
It was Mrs. Crumbley's parents, and those were very short witnesses, so.
That's fine, but
I wouldn't know how long they are. I just,
Okay.
she said there were 2 more other
I
witnesses.
don't have an objection to them having 30 minutes, I'm just saying we're ready to go to closing, which is good news.
I'm not surprised because she was planning on resting, but she didn't tell us that, which is fine. But her client just testified to some things that we really do want to incorporate into our closing.
Okay, well, that raises a couple of questions. One, okay, so you rest. Are you calling anyone in rebuttal?
that's what I want to speak with the prosecutor.
One moment.
In light of-
Hold on.
Sorry.
Okay,
I'm so sorry. This is a lot.
okay, do you guys want a break to just,
If we
Yes.
could,
okay, so they have a right to rebuttal, so I'm going to.
Okay, things are changing a lot, sorry.
Okay, so I'm gonna allow them to have that discussion.
Okay.
But as I indicated yesterday, I think that we've been back and forth on jury instructions. And I submitted to you, I don't know, about 5 days before the trial, what I believed would be the final instructions after consultation with you. And there might be some fill-ins, there might be some things, so I need to know what those are. I make the attorneys sign in blood that they agree to them before closing, so.
Your Honor, just so I can make sure I have the absolutely most updated copy, Ashley, would you email it to me?
Yeah, we
Okay,
did email it to you a week and a half ago, but we have it.
so many files,
We have
I just
it.
wanna make sure that I'm looking at the right one.
We
And I
do-
think
we do have it.
I think we're actually good on those, so.
Yeah.
I think
I
they
thought
are.
before we started, we agreed upon the instructions. I recall that.
Oh, we
first day.
did, but you know, sometimes,
I just need to double check we pull out, like defendant not testifying,
Right.
like the simple things.
yeah, some small things can change, okay? So, you got, do you want to get back to me shortly and let me know if you're going to have rebuttal?
Yes.
Yes, sir.
Okay, because that will determine what we do next and when we do it.
Sounds good.
Thanks,
Right.
Ron.
All right.
All
Thanks,
right.
Your Honor, calling people versus Jennifer Crumbley, case number 22279990FH.
Chair McDonald on behalf of the people.
Thank you, Mark Keeston, have people.
Thank you, I'm Shannon Smith on behalf of Jennifer Crumbley.
All right. We previously drafted jury instructions, and there was briefing and comment on the jury instructions. And I think it was about 2 weeks ago that I emailed a set of final jury instructions that I believe both sides agreed to.
Yes.
But I just want to briefly go over the instructions that we're giving, find out if there's any fill-ins, and then we'll have a final set of jury instructions. I'll provide these to the jury, okay? So we're going to give 3.1, 3.2. We're taking out 3.3.
Yes, sir.
3.5. 3.6. 3.7. 3.10, 4.1, 4.3, 4.4, 4.5. We don't need any fill-ins there, that's general,
Yes,
right? Okay. 4.5, 4.7.
We have not read the stipulations to the jury.
Do you
I don't
guys-
know if we plan to. On the keeper of record stuff, do we need to?
The things that were the subject of stipulations have been
They've
admitted.
already been admitted, so I don't believe it's necessary, Judge.
Yeah.
I didn't know if the court wanted them on the record or.
It doesn't matter to me. Normally, it's advantageous for stipulations to be read into the record, for example, in civil cases with large amounts of exhibits. But if the exhibits that were the subject of the stipulation are admitted anyway, it's probably not necessary. Can you think
These
of,
are just keeper of records, chain of custody. I don't think we need to.
if there's anything that was not admitted as an exhibit, there's no stipulation that doesn't involve an unadmitted exhibit, right?
Correct. Let me
Actually, I'm not
confirm.
sure about
Okay.
that.
Okay, so anyway, 4.7, 5.2, 5.3. What about 5.8A?
I don't think that was
No.
used
Out.
at all.
Out, right?
Oh, thank
Yeah.
you, Judge.
Okay, 5.8A is out.
5.10 needs to be amended.
Oh, okay.
Detective Wojgrowski was an expert, but I don't believe there were any other experts admitted, were there?
No, the two medical examiners did not testify.
Sean and Brian, Pacris and Brian are
Yes,
out,
Judge.
We stipulated to their autopsy
right?
reports.
So it's just Wojgrowski, correct?
Yes, Judge.
All right. 5.11, 16.10. There's several of those as to count one, 16.10 as to count two. That's involuntary manslaughter instruction, 16.10 as to count three, 16.10 as to count four. There's a unanimity instruction that is based on and adapted from 20.30A non-standard civil jury instructions, and the parties agree to that instruction. Correct?
Yes.
Yes.
Okay. 16.13 involuntary manslaughter, failure to perform legal duty as to count one, 16.13 as to count two, 16.13 as to count three, 16.13 as to count four, 16.15 as to count 16.15.
Just one instruction for 1650.
Say it again.
Just one instruction for
Yeah.
1650.
I was trying to see. I think there were some things added. There was a foreseeability excerpt
Yes,
that was
Judge.
agreed upon.
Yes, Judge.
Yes.
Yep, yeah, that's non-standard but agreed to by both sides. 16.18 gross negligence. There's an instruction about not using the shooter's name. Maybe I should get rid of that one. 3.11 deliberations and verdict.
Yes.
3.13, which is possible penalty. 3.14, communication with the court. 3.15, exhibits. 3.16, written or electronically recorded instructions in the jury room. 3.20, single defendant, multiple counts, more than one wrongful act. 3.23, with regard to the verdict form, and then there's the verdict form. That's standard, right?
Yes, sir.
We have obtained a computer that would accommodate the thumb drives that's going to be in the jury room. Anything else you can think of?
I don't think so.
Your Honor, I don't have a thumb drive with mine, I just have my, have a hard copy.
Oh, that's good. We'll send it all in. Okay. Thank you. Let me get it here. Anything else? We're going to make those minor amendments. Anything else at this time?
No, Judge.
I don't think so, Judge.
Okay, so we'll be back in about, well, they're going to take her back down, aren't they? Okay. We're going to take her back down, and I'm going to ask him to bring her right back up, right? It won't take long to do. Okay, yeah, the jury instructions are ready. I think I'm going to give you each a copy of the jury instructions just to be sure that we've done it accurately, all right? And these will be the instructions that go in with the jury as well.
Thank you, Judge.
Okay. At the moment, after closings, I'm going to eventually instruct them. I am going to have all 17 come back Monday, right? Does that make sense to you?
I think we'll get through closings and they could start delivering.
I'm concerned about that. Are you not concerned about that?
No, Judge.
Do you want to approach? Well, a few came out. All right, do you want me to bring the jury in now? Sure.
Yes, please.
Okay, bring the jury in.
One moment, we're just waiting, having some.
I'll just take 1 second to set things up, Judge.
All right. Ms. Williams is going to print a copy of the jury instructions for you, just to be sure, all right?
What's that?
We're going to print a set of the jury
Oh, sure.
instructions, and you can review those, just to be sure that they're accurate before I send them in. 5.8A comes out. 3.3 comes out, yeah. And then the expert witness is only Rothsky, the other two are methods and those will come out, yeah. Okay.
One moment, Your Honor.
It's good, they're lining up.
All rise for the jury.
Ladies and gentlemen, you may be seated. Ms. Smith, am I correct that you rest?
Yes, thank you.
Prosecutor, any rebuttal?
No rebuttal.
All right. Ladies and gentlemen, the evidence in this matter has been concluded, and now we're going to hear closings. I want to remind you that closing arguments are just that. They are how each side sees the evidence in the case. The closings themselves are not evidence. Because the prosecutor has a burden of proof, the prosecutor also has a right to rebuttal after the defendant's closing. All right. I think you're going to hear certain elements again of the crimes charged, and I'm going to be giving you written jury instructions that list those, just so you know. All right. Prosecutor?
Yep, just 1 minute.
I think you can move that if you need to. Yeah.
Yeah, it always seems like a good idea, but I just don't.
Sometimes things become unplugged, that's all.
Sorry, changing my mind.
Yeah, I think you can go forward pretty far. The blue cord.
Sit that way. I'm almost in front of the witness box. Sorry about this. Okay, thank you. Good afternoon. We told you in jury selection it was going to be 3 weeks, and it's now been 2 weeks, so we're a little bit ahead of schedule. This is our time for our closing argument. And I'm going to spend some time going through the evidence, and I'm going to spend some time going through the elements of the crime. I want you to know that I've been watching you diligently, taking notes and listening. So what I'm not going to do is spend a lot of time repeating everything that was said from the witness stand, because I know that you all listened, and I also want you to know that I really appreciate that, and I know the court does too. I told you during jury selection that it wasn't going to be easy, and it was not easy. Listening and watching and thinking about 4 young kids being gunned down in their school is not easy. You listen to every witness, you examine the evidence, and I suspect that many of you feel the way that we do, that it's difficult. But we owe it to the victims and their families to say what really happened. And you've listened and you've done that. In our system of justice, we have different roles to play, and each role is different. There are people who think it's the prosecutor's job to convict people. I don't think that's the prosecutor's job. I think my job and our job is to present the evidence and the facts and tell you the truth. And telling the truth sometimes means showing you things none of us want to see, some of us don't agree with, some of us don't like. But I believe that that's my job. We don't pick or choose the very best things, because I believe that you should have the truth. And I believe that it's not my job, nor is it right, to sanitize what happened in that school that day. Because if we don't tell you exactly what happened, then you don't know all the facts and you don't know what the truth is. My job here, our job, that I believe we have done, is to meet our burden to prove that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter. The burden is high. I told you that during jury selection, but we embrace it. And I believe that we have met that burden. It means that you had to sit and listen to a lot of very emotional things, a lot of emotional people who sometimes aren't emotional, but we're emotional for this, because what happened on that day, every single person in that building had never experienced anything like that in their entire lives. And I hope to God they never do again. So you did see a lot of people, including law enforcement, become overwhelmed with the emotion of it all. That's not a show. That's just how that was. That's how it felt that day and every day after. So I want you to know that there was no picking and choosing the very best evidence to give you. There was no filtering things out that didn't help our case. I showed you everything. And I called witnesses to the stand to say things I knew you probably wouldn't like. But my job is to give you all the facts. But my job is also to prove beyond a reasonable doubt that Jennifer Crumbley is guilty, and I believe we've done that. The defense also has an important job, to advocate and argue for their client, and they decide how they want to do that. And of course, the judge plays an important role. Her job is to call balls and strikes when 2 sides disagree, to make a ruling, and then to tell you what the law is. And she's going to do that as soon as we conclude here. And then there's your job. Your job is to decide what the truth is, what really happened, what are the facts, and then take those facts and find the truth and apply the law. The judge is going to give you instructions about the law, but I want you to go over what you now know, and I want you to think about it. And we're going to go over some of the evidence. But I also want to remind you that you're allowed to use your own observations and your own insight. And if there's something that you notice from the witness stand that I didn't say, you should rely on that. We can't possibly tell you every single little thing. And sometimes, ladies and gentlemen, the most important things are the things that don't get said. The most important things are the way the victim or the witness spoke, the way they answered a question. And I encourage you to rely on your own perceptions of that. I want to start out by talking to you about the elements of the crime. Involuntary manslaughter. She is charged with, this case is based on 2 theories. You're going to have all this in your jury room, but hopefully I'm going to explain it so well you will have no questions. These are dependent on 2 specific theories. One is the gross negligence in the performance of a lawful act, and that gross negligence caused death, and in doing so, the act that caused death, defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. 2, she knew of the facts that gave rise to the duty. 3, she willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And then 4, the death of the victims was directly caused by defendant's failure to perform this duty. Causation. The judge is going to instruct you, maybe more than once, and I'm going to say it, that there may be more than one cause of death. And it's not enough that the defendant's acts made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's actions. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Muir, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendant's acts or inactions need not be the sole cause of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these 4 individuals was reasonably foreseeable. Now you look at that, all of that I have to prove. And it seems a lot. It seems like it's going to take a pretty strong case to prove that. It's going to take some pretty egregious facts, some unique, egregious, incomprehensible facts. And that's what we have here. Gross negligence means more than just careless. It means willful disregard the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you have to find the following 3 things. 1, that she knew of the danger to another. She knew there was a situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third, that she failed to use ordinary care to prevent injury, and to a reasonable person, it would have been apparent that the result was likely to be serious injury. I told you I have 2 theories. We're prosecuting and charging based on 2 theories. They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. We talked about there's 2 alternate theories. Both of those theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven. And as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony. I'm not going to get into every single detail of each of these witnesses' testimony because I know that you were listening and you were writing. You heard from Molly Darnell. Molly was a teacher in the school that day. She was in room 224. And she saw the firearm when it was raised, shoulder height, pointed directly at her. And what she noticed was there was no orange tip. You also heard her say that she locked eyes with Jennifer Crumbley's son as he was taking that stance. You heard her testify that she jumped to the right, thank God, just in time, because the shot in her shoulder that she sustained was only inches from her heart. The next witness you heard from was Christy Gibson Marshall, who's an assistant principal at Oxford High School. I don't think there's one of us that would disagree that Christy Gibson Marshall did the most dangerous thing she could do. And she did not follow the protocol. It's probably one of the most courageous things I've ever seen. She walked to the shooter. She saw a student on the floor. And then, when she finally came face to face with the person who had shot this student, she didn't move. She just stared at him. And he didn't shoot her. She testified that she knew him. She was his principal in middle school. And she just couldn't believe that he would do something like that because she knew him when he was in middle school. You saw the video of that day and what happened. And he just kept going. And even after he left and she had no idea where he was going, she didn't go hide anywhere. She didn't keep herself safe. She bent down to render aid and assistance to that student. And when she rolled him over, she realized it was Taymir. We all know that she didn't and wasn't able to save Taymir. We heard from Cammie Batt, who sold the Caltech and the Derringer to James in June of 2021. She also sold the 9mm Sig Sauer to James with the shooter present on November 26th, the day after Thanksgiving. She testified that James came in and pointed right at the Sig and said he's had his eye on it. She walked us through the process of purchasing a firearm. She talked about the trigger lock statement provided to James upon purchase and the cable lock provided with November 2021 on that gun purchase. Next, we heard from Special Agent Brett Brandon, who's sitting right here. You heard that when he was informed about the Oxford shooting, he left so quickly that when his partner came back, his chair was still spinning. And he raced and drove up there as fast as he possibly could because it was very much his own community. You heard he went right in and he found Lieutenant Willis and he said, do you know where the gun is and do you know where it came from and do you need help? And so he was responsible for finding out where that gun came from, which he did. He was also responsible because he chose to be and watched the surveillance of the video and helped to prepare search warrants. And you heard him testify that as soon as he saw that surveillance video, the one thing that stuck with him is this is not an inexperienced shooter. This is a shooter that that is proficient with a firearm, knows what he's doing. Taking shots, a lot of people wouldn't. And what he did was start going to gun ranges and ask people to say, because what he was thinking was, who taught that kid to shoot? He must have been to a range, and he was right. And that's how the investigation led to where Jennifer Crumbley's son learned how to handle a firearm that eventually resulted in killing 4 students in Oxford High School. Can you go back to that? Special Agent Brandon also testified that and showed the purchase and we showed you each one of those guns. He testified that there is a distinction between a Derringer, a Caltech, and then the 9mm. And what we really heard from him was that 9mm is a much more dangerous gun. It causes more damage to whatever it hits. The bullets are a larger caliber, and it's a very dangerous weapon. He showed you what comes with every gun purchase, which is the ATF pamphlet. He read to you about the warnings. There's a reason they put it in every single gun purchase. And its sole purpose is to protect kids from gun violence deaths. He talked to you about what a trigger lock is and the trigger lock statement. He showed you the Instagram post that's unforgettable. We don't have to really argue about whose gun that was. Jennifer Crumbley told us whose gun that was. She told us when she posted on social media, it was his Christmas present, and she told you in this trial. That weapon is not just that weapon. It is the defendant's son's gun. It was gifted to him. And not only was it gifted to him, she bragged about it on social media before the shooting. Special Agent Brandon also introduced all of the surveillance and the videos of the shooting range. And you got to see with your very own eyes the training and the preparation that the shooter ultimately used to kill 4 of his classmates. We all saw that. We actually saw the last day he was practicing to kill 4 of his classmates. And there was only one person with him, ladies and gentlemen, and her name is Jennifer Crumbley. And I want you to remember that video. And I want you to remember the look on his face when that target comes back in and he looks at it and he's smiling. Special Agent Brandon also introduced the worksheet. You've seen the worksheet a lot. I bet you that worksheet's burned in your memory and I wouldn't even have to show it to you. But what Special Agent Brandon testified to and showed you is that that wasn't just a picture of any gun. It was a picture of his gun, which was the murder weapon. And he showed you the details, and we're going to talk about that later. And next we heard from Ed Robrowski. We now just call him Ed because he works for the Secret Service. And he testified for an entire day, and he had a lot of information. But he also really couldn't help himself from becoming emotional. And I know that you're going to remember this, but what an extraordinary thing that's just not seen very often. He sat right there and he took you through every single action of the shooter and every single death from his memory. And he told you that he could do that because it's burned in his brain. These are seasoned law enforcement. This isn't an act. They hate showing emotion. He probably will never forgive me. Lieutenant Willis tells me all the time how much he really hates me
Your
for
Honor,
that.
I would object.
It's my opening. It's my closing. Your Honor.
What
Just
a
let me get
witness tells her all the time, that's not evidence.
through. Okay. I'll move on. Okay. Nobody likes doing that. Nobody likes doing that. But it tells you something about what it was like that day. And despite what anybody will tell you, it is about the shooting. There are 4 counts of involuntary manslaughter. It's very much about the shooting because the shooter learned how to shoot and was given the murder weapon by his parents. And this parent is sitting here today on trial. Okay. You'll be able to review the evidence. It was a lot. But he talked to you about what cell phone extractions are. And because of the cell phone extractions, we have a mountain of evidence that you saw. And yes, it's a lot of data. But you know what else it is? It's telling you exactly where the defendant was, who she was talking to, what she did, what she didn't do. And you can't hide from that. She tried. There's a lot of deleted messages, which are not coincidental. I don't think any of you believe that, but I'm going to tell you why they're not coincidental. He also talked to us about and showed you the messages between Jennifer Crumbley and her son. The messages between her son and his only friend. He introduced the voicemail that Jennifer Crumbley received the night before the shooting about looking up bullets. True. Pam Fine didn't tell her to call back. That's true. And she didn't call back because she didn't ask for a call back. We all know what she did do with that information. What she did do with that information is she texted her son searching bullets. And we all know the phrases that we'll never forget. Did you show him your gun? This is the day before the shooting. Did you show him your gun? And the shooter responds, no, my God. LOL, I'm not mad. You just have to learn not to get caught. Kira Pennick testified that she knew Jennifer Crumbley. She testified about the amount of time that Jennifer Crumbley and James Crumbley spent at the barn. She testified about all the money they spent at the barn. Why is this important, ladies and gentlemen? It's not to show you that somebody's a bad person for liking horses or spending a lot of money on horses. It isn't. And it's not to say that somebody should spend every waking hour that they're not at work at home with their teenager. That's not the purpose of this evidence. The purpose of this evidence is to show you what Jennifer Crumbley cared about the most and what she was doing and where she was when her son learned to be a killer. Kira will tell you that she referred to her son as an oopsie baby and said he was weird. She rarely saw him. And that even after the one friend was taken away abruptly with no notice, they still went to the barn even at night and left him by himself. Which is absolutely normal to leave teenagers at home by themselves. Unless that teenager is showing signs of mental crisis and that teenager has lost the only person in the world that he has. And then she told us that when she got the worksheet texted to her that day by Jennifer Crumbley, she was very concerned. She was alarmed. And in fact, she said, bring him to the barn. And you also saw from the text messages that Jennifer Crumbley said, he can't be alone. We know now. That decision, that statement, she knew he couldn't be alone. She didn't decide to stay home with her son. That wasn't an option. She'd have to take him to the barn, where she herself testified he didn't want to go. You heard from two people who were at that meeting that day, Sean Hawkins and Nick Ejak. I'm going to tell you right now that this is not an argument that the school did everything they should have done. I'm not going to say that to you. I'm not going to tell you that I like everything they testified to. I'm not going to tell you that I think that it was okay they didn't look in the backpack. I don't think it was. But this is about Jennifer Crumbley's actions. And any attempt to make it about what these two individuals did or didn't do, like it or not, who did not have any of the information that was so jarring, it's about what she knew and what she didn't say. Sean Hawkins testified that he was concerned enough that he called Jennifer Crumbley. And her first response is, can you call his dad? Eventually, he emails her both copies of the worksheet, the original worksheet and the worksheet that was scribbled on. And she eventually comes to the school. But before she comes to the school, she texts her husband, emergency. Emergency. Along with, I'm very concerned. And James texts back, WTF. They're concerned. For the first time she testified ever, they're called to the school in the middle of the day, and they have that worksheet. Sean Hopkins is going to tell you that calling parents in the middle of the day and asking them to get a kid help is a pretty drastic action. And that he did in fact do that. And he gave them a list of places to call. He testified that when they entered the room, Jennifer Crumbley didn't greet her son. Jennifer Crumbley didn't hug her son. Jennifer Crumbley didn't engage with her son at all. In the entire 11 minutes she was there. And we know she wasn't going to be in that school very long because she'd already told her boss she'll be back by 12 or 12:30. Doesn't leave a lot of time for the meeting at the school. It's a 20-minute drive. Sean Hopkins will tell you that what he felt mostly in that room for the shooter was compassion. He didn't want him to be alone, and he felt really bad. And he also knew mom and dad decided, no, we can't take it. We have to go to work. They said that in front of their kid. He knows very well what they do. He knows his dad works for DoorDash. He knows his mom and her ability to work flexible hours. She worked at home. But they left. She did not hug him goodbye. She did not touch or even acknowledge him. And we know now from her testimony, we know why. She was mad. She was mad at him. She did not think that he should have done that, and she thought this was a discipline thing, and she was very angry. We heard from Nick Ejek. He's the Dean of Students. He also testified and corroborated what Sean Hopkins told you, which is that the meeting was called, they were concerned about a mental health issue. They told mom and dad he needs services. Here's a list of the services. And Jennifer Crumbley seemed irritated by it. In fact, when she walks into the room, she doesn't sit next to her son. She goes back here and stands. And that meeting ended with her saying, are we done here? They're consistent about that. Nick Ejek testified he didn't think there was any risk. I don't like what he said, and I knew he was going to say it. But it's not my job to put witnesses up here and only say things that I want them to say that helps my case. It's my job to present evidence that's the truth, because you have to know the truth. Sergeant Joseph Bryan is the first law enforcement that had contact with Jennifer Crumbley and her husband right after the shooting. And you saw the interview in the substation. And you saw the demeanor of the defendant. I want you to remember something. It wasn't even an hour. It was around an hour after the shooting took place. She's on her cell phone. She's looking to see if it's on the news, she said. We also know that there were deleted messages. We don't know when she deleted them, but we know there were messages deleted after the time of the shooting, from the time that the phones were seized later that night. He asked about the gun, and you heard what she said, what they both said. It was hidden. It was hidden. She read the text message. Oh, he said he loved me. And she reads a text message. And then she said, I texted him, I love you back. It was 49 minutes later that she texted, I love you back. And it was after she already knew that he was the shooter. She doesn't say what the text after that is. She leaves that out. The text after that is, Ethan, don't do it. She doesn't say, well, we were at the school, but he was also caught searching bullets that night, the night before. She doesn't say that, and I told him, don't worry about it, just don't get caught. She doesn't say that they had just purchased the weapon and it's not secure. What do they say? The very first time they are asked about what Jennifer Crumbley's asked, where was this gun? The very first time, what does she say? It was hidden. She does not say there was any locking mechanism at all, and neither does James. It was hidden. You're at the police station. Your son's in the next room. You know the murder weapon was the weapon you just purchased for him, and when you're asked where it was, you say it was hidden. We also heard from Andy Smith, who was Jennifer's boss. He testified she could have absolutely gone home. She works from home and there's flexibility, that they have kids that come to work, that the meeting that she wanted to get to was not in any way mandatory. And he testified about some very bizarre communications. He testified that as soon as she left, he got a text saying, my son, the bullets are gone, the gun is gone. He must be the shooter. Oh my God. Those were deleted by Jennifer Crumbley. We don't know why. I think there's a lot of circumstantial evidence to suggest why, which is those are statements you don't want on your phone. And then, not 3 hours after her son shot and killed 4 people, and he's already in custody, and it's already clear that he is probably never, ever, ever going to be out of prison for the rest of his life. She's texting, don't judge me based on what he did. I need my job. Her explanation for that, she was in planning mode. The next witness is Amanda Holland, who testified that she came back to the work that day. She had the worksheet. Andy Smith also said she before the shooting occurred, she was down, she was sad. I feel like a failure as a parent. I feel like a failure as a parent. This is before the shooting. And she also tells Amanda about this, and she tells Amanda he can't be alone. So I'm just going to take him to the barn tonight. We can get to it a little bit later. I guess what's really hard to comprehend is how before the shooting, just based on the meeting and what she knows and the drawing, she thinks she's a failure of a parent. But she sat right here and said, after all, she doesn't really think she was a failure as a parent. And that's after she knows everything that happened. Detective Adam Stoyat executed the search warrant at the defendant's home. I want to make it really clear. Jennifer Crumbley is not being charged with involuntary manslaughter because she has a dirty house. That's absurd. And you can see pictures so we can prove that she didn't have her house clean. I don't care if her house is clean or not, and I don't think you do either. Those pictures are shown to you because that is where the shooter lived and it's where she lived. And you saw his 2 bedrooms. There was barely a place for him to sleep. The testimony shows he had no person in his life after that friend left. He was not in a club. He was not in sports. He wasn't working. When I see those photos, what I think is, 2 rooms that were completely filthy, dusty, covered with clothes everywhere. But then I think, what? That is where he spent 99% of his time. It's where he ate Thanksgiving dinner, just days before the shooting. The search warrant photos were also shown to you so you could understand where these guns were stored. We have a pretty good idea that the Kel-Tec and the Derringer were in what's called the gun safe. The lock was 000, but we know that they were kept there. What do we know about the SIG, the Jennifer Crumbley's son's gun? We know that there was a box on the bed and the ammunition next to it. This is the box. This is the box. I'm sorry, this is the thing. Get the other box. I was going to show you in a minute. This is the box of the Kel-Tec, which was found with this cable lock inside of it. Where she kept the other guns? No.
I'm sorry, is that the box or the case? Is that the box or the safe?
This is the box.
That's the box. Yeah.
It was in the kitchen, in a cupboard, down in the
But
cupboard.
the empty box was in the kitchen, right?
I don't know, what exhibit number is that?
This is my closing argument, and I would just like to finish, please.
Sure, can you tell us what exhibit number it is?
Yes, it is 35.
Go ahead.
This was found in the kitchen. Inside is a cable lock. This was found on the edge of the defendant's bed. Special Agent Brandon showed you what it's like to open this up and close it. You hear that clap? It's not an easy thing. So what this was laid out on the defendant's bed, and the bullets are right next, the box of the ammunition is right next to it, empty. The story, one of the stories that is told by Jennifer Crumbley is he must have come in there when they were sleeping. And she was in that bed all night long, and they left after her. Except that the ammunition was in the box. Taking it out and leaving the box while your parents are sleeping doesn't make a lot of sense. And it doesn't make a lot of sense that this was taken out, the weapon was taken out of this case with no one hearing while they were sleeping. And you are allowed to use your own common sense. He also testified about the search warrant. He testified where this cable lock was found, and he testified where the case and the box was found. And he testified where the gun safe was found. It was not, unlike what Jennifer Crumbley alleged, stored separately from the ammunition. It was actually right next to the ammunition. In a gun safe, the other two guns with the combination 000. Sergeant Peschke arrives at the scene, doesn't know anything about the Crumbleys, doesn't know that they've already been to the substation, doesn't know that they were at the school that day. He's there and was ordered to be there to keep the house safe while they are waiting for the search warrant. And in doing so, he needs to keep the defendant out of the house. She goes in the back of the car, and you saw the video. She now tells Sergeant Peschke she actually never really looked closely at that worksheet. Now that she looks at it, it might be disturbing. We know that's not the truth. The question is, why is she lying? She says that the .45 caliber gun used at the school, and he asks us it was, and tells him no, it was a 9mm. The other is a .22, I think. She said that they had a fight the night before with her son over grades. And she says, so we told him, no gun rage, no phone. Those are his trigger points. Ladies and gentlemen, that phone was never taken away from her son. We know that. We know that because he had it the night before, and he had it at the school. We know that because when Jennifer Crumbley was asked about it, and asked, when did you take this phone away? We know that he made that video in that shed about the school shooting with his phone at 10 o'clock. The phone was never taken away. Why is she saying that? I don't know. Then she says, my biggest fear was that he turned the gun on himself. And when he asked her, do you ever keep guns in your car? Here's what she did. Shook her head. It's not what she says here today. Next, we heard from Bob Patelis, who processed the scene. And you saw those pictures, and they were hard to see. He told you that there were 32 fired cartridge casings. He collected all that evidence, took all the photographs, and recovered the murder weapon. Lieutenant Marsvan was also at the school that day, and he testified that he picked up the phone and saw the screen and saw that the last text was, Ethan, don't do it, from Mom. He executes search warrants for all of the devices and the home and sends a team, including Officer Peschke, to secure the house before the search warrant is executed, which is what they do. He testified that when he went into the house, he finally got there and he needed their phones. And he testified that Jennifer probably said, no, I don't want to give you my phone. I'm not giving you my phone. She finally relents because her husband says they're going to get it either way. And then she doesn't want to give the passcode up. She doesn't want to give the phone up. But the most important thing that Lieutenant Marsman said is when he described how he had to identify the body of Hannah in Madison that day. Dave Hendrick is retired, but he's the former sergeant in charge of the fugitive apprehension team we call FAT. And his job, his only job, when he was doing that, is to find people who have felony warrants and haven't turned up. He has a lot of ways to figure that out. But he was asked to find Jennifer and James Crumbley to make sure they turn themselves in. But one of the other primary goals he has is that they turn themselves in safely. And she was given every opportunity to do that, and she did not. I want to talk to you about something. The judge is going to instruct you that you can consider flight. It's not an element to the crime. I don't have to prove that they fled. The reason we introduce this evidence is she's going to instruct you that you can use that as a sign of consciousness of guilt. What do you do if you know you've done something wrong? You can use that to show consciousness of guilt. And we're going to get to it, but I believe we have shown that beyond a reasonable doubt. He's going to tell you that the defendant with her husband immediately began to avoid detection because they're pulling cash out. They're pulling cash out of their son's bank account. They're pulling cash out of their bank account. Where's their son during this time? He's at Children's Village being arraigned with his court-appointed lawyer, where they had the opportunity to go see him, where they had the opportunity to go to that arraignment, and they did not. Because they never even went, they fled their house and went to a hotel, and then they ended up at an extended stay, and that is where they ultimately left one of the Kias, backed into a parking space. He's going to tell you that he eventually did apprehend the defendant. You've heard a lot about that. And he's going to tell you that there were hundreds of law enforcement officials on the scene when she was apprehended. Luke Kirtley, I know you will not forget him, coincidentally knew a lot about cars and coincidentally pulled into that parking lot right about the time and coincidentally had just seen the wanted poster, he called it, and with a description of the cars and a photo of the defendant. And coincidentally thought, maybe that's the car. And you watch the video where he goes around and he sees the license plate and he plays it cool and slowly walks into the building and then makes the call to 911. He describes to you how within minutes, police officers arrived and then swarms of law enforcement arrived, SWAT, the marshals, ATF, the Sheriff's Department, Detroit PD, all sorts of law enforcement show up immediately. He also testified that the unit where Jennifer Crumbley was actually found was very close to his, and it faced the parking lot, and the whole wall was windows, and it was on the first floor. And he's going to tell you that the whole parking lot was lit up with law enforcement, lights, sirens, all kinds of things. Next, we heard from Corporal David Shaw, and he testified that once he got there, they took a 35-pound ram to breach the door, which was right outside the unit where the defendant was found. We heard from Brian Maloche. Also, didn't love a lot of things he has to say, but you deserve to know the truth. And the truth is, like it or not, this is who Jennifer Crumbley spent her time with, and she told him that morning, the gun's in my car, and I'm afraid my son's gonna do something stupid. Before the shooting, the same day. You also learned that although their Facebook thread in general was always deleted, after the shooting, it remained, except she deleted, not unsent. Rely on your own memory about what that testimony was. Those were not unsent messages, they were deleted, and you heard Edward Growski tell you that. But these were the two that were deleted. On the run again, and we're fucked. William Preer testified what was found in the building and the art studio where Jennifer Crumbley was found. You saw the photographs. You learned that there was a little over $6,000 in cash. You learned where the phones were found, and the cash, and the purse, in the plastic tub, in another plastic tub with the lid on it, feet away from where the mattress was, and there are other things where you learned all those phones were off. He also testified what else was found. Booze, orange juice, ice, and avocado, bananas, socks, blankets. And that is the room where Jennifer Crumbley was ultimately apprehended. You heard from Lieutenant Willis, who was the officer in charge. He told you what it was like in the school that day. He described the autopsy protocols that were done and how each of those kids died and where they were shot. He told you that both Justin Schilling and Madison Baldwin were shot in a contact wound, which means the gun was either very close or actually touching their head. He showed you the video of the shooting. And again, this is not to incite emotion. The video of the shooting shows Jennifer Crumbley's son taking a stance he clearly knew how to take and was trained to take. And you watched his demeanor and the calculated, cold way he proceeded through those hallways looking for people to shoot. You saw the surveillance of how he ultimately surrendered. Walked out after executing Justin Schilling, laid the gun on a wastepaper basket, made it safe, took the magazine out, and surrendered. He showed you and introduced the bank records that show you what they were doing after charges were either very soon coming and after they were announced. And he showed you an in-car video of Jennifer Crumbley and her husband, who just a few hours after the shooting embraced, kissed, whatever happens, I love you. Don't say anything to the police. One of the elements we have to prove is what a person using ordinary care would have known about whether or not there was a situation that they needed to exercise ordinary care. So the defendant's knowledge about her son matters. But it's two different stories. It's what she knew before the shooting, and it's what she said she knew after. Before the shooting, she tells Kira, my son's weird. She always refers to him as an oopsie baby. She tells Amanda Holland he's lonely. He's hearing things around the house sometimes. She says, I'm a failure as a parent. The message to her son's friend's mother, he's kind of depressed in April. She texts that. And then the messages from her son, the messages in March about he's seeing things. Things are flying off the table. Now she wants to tell you that was just a joke, but I think you really need to consider whether a 15-year-old boy is going to text, could you at least answer me or reply to my text as a joke? And we know there were no replies. There were missed calls. He called her. There were no replies. And she told us why. He was just messing around. But after the shooting, in the in-car, we hear her say, he's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. Also in the in-car, I never even thought like he would have any mental issues. Like he never exerted any type of anger. He's never exerted anything. He's just like one of those mellow, laid-back kids. In the substation, he's never done anything. He's never done anything bad. After the shooting to Brian Maloche, he's never done anything wrong. Jennifer Crumbley has said a lot of things about that drawing in that meeting at the school. She sent the drawing to James and Kira and Andrew, as I said before, with the call now emergency. She told Kira he couldn't be left alone. She tells Andy she needs to get him counseling, and she tells Amanda that the drawing was really scary. She agrees. After, this is what she says in the substation. Nobody didn't seem worried about it, and he said that my son's more than welcome to stay at the school, or he could go home. And I really wish we had taken him home. In the in-car, she said, I didn't even look at that closely. Now that I do, when I was at the substation, I looked at it closely, which we know is not true. I looked at them closely, and they're a little disturbing. Well, they're very disturbing, because look what he just fucking did. And then to Maloche, she says, the school was very nonchalant, but the paper they showed me had all of the things scratched out. That's just not true. It's just not true. And you don't have to believe me, because we have evidence it's not true, and you heard it. The statements about the gun are also numerous. She said, we've heard her testify the gun was in her car. We know that she's acknowledged that she drove to the gun range. There was no lock on the gun when she drove there. She returned with the gun. There was no lock on it, but she said James locked the gun when he got home. She didn't see him do it. She testifies at trial. James is responsible for the gun. In the substation, though, when asked where the gun was, hidden. In the in-car interview, James flew home and he's like, I had the gun hidden and I told him where I hid the bullets. He asked whether she kept the gun in her car. She shakes her head no. And she tells Maloche, after, the next day, we had the string lock on it. It came with in the case. Everything was secured, not loaded, bullets stored separately. Oh my God, oh my God, oh my God. That is not what she says in the substation. Jennifer Crumbley begins distancing herself from her own responsibility about the gun. You heard her testify that they wanted to get the gun. It was my son and my husband. My son did a lot of research on the gun. I guess when I was shopping. She doesn't say she didn't know. She doesn't say that she didn't approve. She says it really interfered with going to get Christmas trees. That was what she was upset about. And she said it's James's responsibility. However, as I've shown over and over, at the substation and in the car, it's we. It's we take him to the range. It's our hobby. We go to the gun range. That's what we do. We just got him this gun. Sitting here today, it's all James' fault. It's not hers. And then, of course, the statement that we don't really have to question whose weapon it was. Jennifer Crumbley posts, Ethan and James Crumbley both got handguns this week, testing them out at the range. That's in June. The evidence really shows that the shooter owned 2 guns. But for sure, she acknowledges Mom and Sunday testing out his new Christmas present. You heard evidence that was presented to you about the journal that was found in the bathroom by the shooter's backpack, right before the bathroom that he exited and started shooting. I have zero help from my mental problems, and it's causing me to shoot up the fucking school. Next slide. First off, I got my gun. It's an SP 2022 Sig Sauer 9mm. The shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this, so yeah, I'm going to prison for the rest of my life, and many people have about 1 day to live. One of the things I want you to ask yourself when you go back in that room is why, after hearing that there's an active shooter situation and knowing that your son is involved, you are taking the time to delete text messages. And look at the messages that were deleted. We're on the run again. Helicopters, not sure where to, I'll message you, and we're fucked. Delete, the gun is gone and so are the bullets. Oh my God, Andy, he's going to kill himself, he must be the shooter. Ethan did it. Those were deleted from her phone. She deletes all of the things she says about the drawing to Kira, including making sure that she still was going to get her lesson that night. This is the timeline from when in March, which you've heard a lot of testimonies starting in about March, was where we first have evidence that he was struggling, he was hallucinating, he was seeing things, and he wanted her to text back and she didn't. We know that he had some incident, and he says it's a mental breakdown in April. You saw text messages between James and Jennifer saying, did he say anything about last night? He woke up in our bed, he didn't know where he was. We don't know what that was about, but we certainly know that that is not evidence of somebody who is completely fine and stable. In fact, lots of messages from Jennifer Crumbley saying, I'm worried he's gonna do something stupid. In April, she texts her friend that she thinks he's depressed. The Caltech and the Derringer was purchased in June. They go to the shooting range in June. They go to the shooting range in August. They go to the shooting range in September. And then in November, they buy the Sig Sauer. And we see the shooting range that Jennifer Crumbley went to with her son, testing out his new Christmas present. Here's what we learned Jennifer Crumbley did after the shooting. As soon as they took her phone, they bought burner phones in Lapeer at 8 o'clock the night of the shooting. They checked into a Holiday Inn Express that night in Lapeer. They then left and went to an extended stay in Auburn Hills, which Lieutenant Willis testified was almost across the street from the police department. Upon learning that charges were possibly coming, and the same day charges were announced, they leave that hotel and drive to Detroit. They withdrew $2,000 from a Flagstar bank on December 2nd. They drive to Owasso, an hour away, she says, because we just didn't want anyone to recognize us, to buy replacement phones. She texts that she's on the run again. Helicopters are not sure where I'll message you to, at 7:31 a.m. on December 2nd. She texts on December 2nd, we're fucked, at 2 o'clock. On December 3rd, at 4:59 a.m., she texts, I'd rather die than go to jail. Then she withdraws $4,000 from another Flagstar on December 3rd. She checks out of the extended stay on the 3rd and drives down and arrives at Bellevue at 10:58 on December 3rd. You heard what happened. You heard her testimony. The facts do not support the story that Jennifer Crumbley told you. They just don't. There is no possible way, and Luke told you that, and so did Corporal Shaw, that it would you could be in that building with that many law enforcement and not know that somebody was there. And we don't even have to use that today's testimony, ladies and gentlemen, because she texted herself, I think we're caught, we're laying low. She texts that, we find out, and this is evidence we got this morning. She texts that after she's already said she took 4 Xanax and went to sleep. Now you saw that video. You saw that video. All those people for over 2 hours, they're sleeping, and even when they come into the room, they still don't even act like they get up. It's just not true. And we know it's not true because they'd already taken steps. She had hidden the phones, powered them down, separate from all the other things they had, with the cash. Jennifer probably wants you to believe that if only the school had done something different, we wouldn't be here. If only the school. Well, let's talk about what she knew that no school employee knew. She knew about the text messages in March that he was about a demon, throwing bowls, clothes flying off the shelf. She knew about the March 18th incident of waking up in his parents' bedroom and like he had way too much to drink and asking why he was in their room. She knew he had previously asked for help and to go to the doctor, and she laughed at him. She knew there were multiple guns in the home. She knew her son had been gifted a gun just a few days before the shooting. She had posted it on Instagram. But apparently, it's absolutely fine for all your Instagram friends to know that you got him a Christmas present with a 9mm handgun, but it's not okay or relevant to the people sitting in that room with that drum. She knew that that gun looked identical to the one in the drawing. She knew that the gun was accessible to him. She knew it wasn't stored properly. She knew that he was proficient with the gun. She knew he had access to ammunition. And she knew that her son was upset the night before. Now, that says he was locked out. She told Amanda Holland he got locked out. She doesn't acknowledge that. She does acknowledge that he did leave the house that night because he was upset. And we all know what he did. We all know what he did. He went to that shed and he recorded that video.
I object, that video did not come into evidence.
Okay, it isn't in evidence. It is not. You're right.
It's true. Mm-hmm. Let's go back to the elements. Ordinary care. What ordinary care, the smallest, tragically smallest thing she could have done to prevent this. She could have stopped at home on the way back from the meeting. She goes right by her home to see where the gun was. She could have stopped on the way back to work. She could have searched the backpack. She could have asked her son where the gun was. She could have locked the ammunition. She could have locked the gun. She could have taken him home. She could have taken him to work. He could have gone with dad. He was door dashing. She could have told the school that they just gifted him a gun. She could have embraced her son. She could have said, can we talk to him for a minute alone? She could have looked at him and said, I care about you, I love you. She could have at least acknowledged he was in the room. She could have told the school about her son being in crisis previously and asking for help. Ordinary care would have included all of those things. And the tragic part about it is none of it was hard. None of it. The smallest thing, just the smallest thing, could have saved Hannah and Tate, and Justin and Madison. The smallest of things. I have to prove that there's reasonable foreseeability. And that worksheet right there that Jennifer Crumbley saw just hours before the shooting is reasonable foreseeability. And we're gonna show you in the next slide. That's the picture of the gun. It's not just any gun, ladies and gentlemen. It's the gun that they just gave him. Blood everywhere, that's what he wrote, with ammunition. I didn't show you the picture with the blood, because I don't think you need to see it again. But we know what happened in that school and in that hallway. Here's a picture with 2 bullet holes and blood coming out of the figure's head. And look at that, though, that is where those shots went. Those are from the shooter's gun. The thoughts won't stop. Help me. These are all of the things that were texted to Jennifer Crumbley. This was in March. But he's writing it on a piece of paper and he's showing it to her. That is foreseeability. He's telling in that drawing, this is the gun that was purchased for me. Help me. Blood everywhere. The world is dead. I know you won't ever forget the video, but if you look at the defendant's son and see that there was no emotion, none. He was only concerned in a very calm manner for finding as many people as he could to kill, and he did. My life is useless. These statements from the defendant's son are just heartbreaking. I asked my dad to take me to the doctor yesterday, but he said, just give me some pills and told me to suck it up. Like, it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I am having bad insomnia right now. I need help. I was thinking I could call 911 so I could go to the hospital, but then my parents would be really pissed. Like, I am mentally and physically dying. Let's talk about the cable lock. Jennifer Crumbley says that the cable, the weapon was used, but it was locked in a cable lock that came with the case. This cable lock? This cable lock that came is the cable lock that came in that case with the SIG. It's never been opened and it's never been used. This is the last picture that we have of that gun until we see it murder 4 kids on November 30th. And the person holding it is Jennifer Crumbley. She's the last person that we see with that gun. She's the person that said it was in her car, then she said it was in her house, it was her husband's responsibility, it wasn't hers. That's what she told you. She knew he was distraught the night before. He texted her, I love you. She told you that's never happened before. She did think it was abnormal or odd. She knew he was looking up bullets in the school. She knew he was watching violent videos. She knew he was proficient with guns. She knew he was previously in crisis. She knew his only friend that he talked to was just gone. She knew all those things. And then her own statements, ladies and gentlemen, when she took the stand. She testified that when she's looking back, she still wouldn't do one thing different. Not one. Not any of those tragically small things. Even now, she told you she wouldn't do anything different. And then she also told you that we took his gun away. You heard her say it. And then she said, she doesn't think of herself a victim, but she has lost everything. You're gonna hear the instructions from the judge, and you're gonna take the facts and the witnesses and the evidence and use what you promised to use, which is impartial, honest assessment, and find what you believe the facts are in this case. The flight, evidence of the flight and what they did after is not an element I have to prove. But what does it show? It shows the minute this shooting became public and ended up in the paper and the media, Jennifer Crumbley started telling a story, and then she ran. And she didn't run just because she was selfish, ladies and gentlemen. She ran and she started deleting text messages, and she started telling a different story because she knew she had done something wrong. That's the only reason you start deleting text messages. It's the only reason that you start saying something that isn't true. It just isn't true. Jennifer Crumbley drove to Detroit with a bunch of cash and 6 cell phones powered off. You can consider that as consciousness of guilt. Everything she did from the time she found out that there was an active shooter and had the 10-minute call with her husband. They both say they went right, he called 911 right away. He did not. He talked to his wife for 10 minutes, over 10 minutes on the phone before he called 911. But the facts changed because it was an immediate attempt to misrepresent what actually happened. Why is a mother whose son just killed 4 people thinking about deleting her text messages? Why is she saying things that are not true about her son? Why does she care about her job? Why does she care about her horse lesson? Why does she care about any of these things? Because she knew she did something wrong. And she's deleting all of those things because she wants you to believe that she's somebody she's not. And you know what she's not? She is not somebody that used ordinary care to prevent what was foreseeable, reasonably foreseeable, that could have happened. Injury or death, and it did. It did. Those words on that paper helped me. She walked out of that school within 11 minutes, didn't so much even address her son. She did not give him the help that he wanted. And you can argue about the months before and the weeks before, but if you just even look at what happened that day, she walked out of that school and she knew something bad might happen. What does she do when she gets back to work? She all of a sudden texts her son, "Are you okay? You know, you can talk to us." These are the actions of somebody who was worried. She was worried and she was concerned and she was panicked until after. And then it's a different story. Why? Because she knew she had done something wrong. She walked out of that school when just the smallest of things could have saved, could have helped Hannah and Tate and Madison and Justin. Just the smallest of things. And not only did she not do it, she doesn't even regret it. We have proven beyond a reasonable doubt that she is guilty of 4 counts of involuntary manslaughter. It's a rare case. It takes some really egregious facts. It takes the unthinkable. And she has done the unthinkable. And because of that, 4 kids have died. So I'm asking you to go back when you hear the law, review the evidence, and find her guilty, because we have proven our verdict. Thank you.
Thank you.
Your Honor, I am ready to go, and I will, but I'm going to need to use the bathroom halfway through if I start now.
Okay.
Can I have like a 3-minute bathroom break, literally?
Do you guys want a break? Okay, so we're gonna take about a 5-minute break, and then we'll hear the defense counsel's closing, okay?
All rise for the jury.
All right, you may be seated. I don't want to pressure anyone to speed up their closing, but both sides have asked me to let the jury deliberate today. I'm gonna talk to the deputies, but I'm not positive that's possible. I'm not positive it's possible.
Okay, I'm gonna run to the bathroom, thank you.
All right. You have to take her down? Okay, they're gonna take her down, okay.
Your Honor, calling People v. Jennifer Crumbley, case number 2279980 FH.
All right, one thing I wanted to tell you, I've been using up all my brownie points for the captain who has told me that we could stay later than we need to, if that's what you want to do. I'm concerned about sequestration and all that. When we pick 5 alternates, I'm going to put 5 alternates in another jury room, and they're going to remain sequestered in the same way that the 12 are. So 5 are going to sit in another jury room. If we come back Monday, I'm still bringing the 5 sequestered jurors back here. All right?
I think that's smart.
Yeah, oh, well, okay.
I know it's awful for them, but if one of them goes down.
Okay, yeah, no, I'm concerned about that, so that's what we're gonna do, all right? So I just wanna let you know, because when they go out to the jury room before I pick the 5, I'm gonna have them bring their personal things out here, because then they'll be separated, right? Okay. All right, so I'm gonna bring them in, all right?
Yes.
All rise for the jury.
All right, you may be seated. We're now going to hear the defendant's closing. All right, Ms. Smith.
Yes, thank you. As the prosecutor finished, she said, "This is shocking, unthinkable." I believe there were other words used throughout trial. Unbelievable. Obviously, unbelievable, unthinkable, unfathomable. And the reason that's the case is because it was unforeseeable. No one expected this. No one could have expected this, including Mrs. Crumbley. Now, the first thing I want to do very quickly is talk to you about the burden of proof. In the state of Michigan, there are different burden of proofs depending on what kind of a case it is. When people sue for money and say, I've been injured or I was failed by the school even, there will be civil lawsuits and the burden of proof is a preponderance of evidence. That means it's about a 50-50 standard. And if you have 50% of the evidence, that's the burden of proof for civil. When the state thinks it's important to take away a person's children, the burden goes up. And the burden has to prove more evidence, and that specifically is clear and convincing evidence that it's correct for the state to be taking away a person's children. Now, the highest burden in this country is in a criminal case, and that is beyond a reasonable doubt. And the reason I'm telling you about the differences in the burdens is because in a criminal case, if you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilties. You have to be sure beyond a reasonable doubt. And later, as I go through my closing, I am going to tell you the reasonable doubts that the defense believes exist in this case for you to look at. The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything. Like Judge Matthews said, we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in bits and pieces. And the problem in this case is that we can all agree everything can be seen different in two ways. First of all, when you look back in hindsight with 20/20 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong conclusions. Now, during jury selection, it felt like the prosecutor was asking you questions and giving more of a campaign speech than a jury selection proceeding. And I would suggest to you that at the end of the day, the only judge, although Ms. McDonald mentioned she's been a judge and was a judge several times during her jury selection, the only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Ms. McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter. The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown. So during this case, it's obvious real life is messy and complicated. And during this trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly. I say I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry through this whole trial. And all I'm saying is that I'm human. I am a human being, and so is Mrs. Crumbley. And that's what this case is about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt, bad with technology, which is why you're not going to see me touch that laptop. So during this trial, I have stood before you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. She got on the stand and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see the whole truth, the entire truth, and nothing but the truth on everything. where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped off her armor, let the prosecution cross-examine her, and show you what happened in her messy life. And I say that with all kindness because I'm a mess too. I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got to be honest, as a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful of wipes and scrub off the best I can on my way running out the door, putting on my makeup as I drive to court in my car. Because my life is not perfect and no one's is. And during this trial, you may have concluded that you don't like me, that you hate me. That's fine. I am just asking that your opinions about me as a person, and if you're one of the people who plans to make a TikTok about me, that you won't hold those opinions against Jennifer Crumbley and will judge Jennifer Crumbley's case based on the evidence about her and her family. And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After trial, you don't have to decide if you want to go to her house. You don't have to have Thanksgiving with her. But when you're looking at the evidence in this case, it's important to set aside your opinions of her or take your opinions of me and supplant them on Mrs. Crumbley. Now, when I took on this case pretty early on, I realized I am Jennifer Crumbley and I could be here accused and sitting in her spot very easily. Now, in my house, we don't have guns. I don't have guns, but I do have children. And actually, I have an oopsie baby, my fourth one. I did not want 4 in 4 years, but that's what I was blessed with. I say I'm abundantly blessed. And I have kids that seem to have no issues. And at the end of the day, they're good kids. They go to school. We have no discipline problems. We have arguments here and there, just like every family does. I have a son that wants to hang out with me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar and walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen. And if you saw the text messages that my husband and I exchange on a daily basis throughout this past year and even years before, it would be so easy for me to be in her seat. With my kids, I don't monitor assignments. I don't look at their phones. I have no reason to. My son plays a lot of video games. My son's online talking to a bunch of people as he's playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day. And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone I own but let him use and gave him for his birthday when he turned 11, Should I be held accountable for receiving child pornography if a girl sexts him over some inappropriate pictures? If my son decides he's gonna send some pictures back and takes a nude picture of his bits and pieces, that's a 20-year felony. Am I then responsible because he sent a picture of his penis over to some girl? So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable, and this clearly was not foreseeable to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would have let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well. She would be the first person on the planet who would have never let that happen in a million years. So this case is a very dangerous one for parents out there. It just is, and it is one of the first of its kind. Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt, not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case. You don't have to agree on what the doubt is. And for that reason, what I am going to do is show you all of the doubts that the defense believes exist in this matter. Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. So the first place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine. We stipulated that what happened to Molly Darnell and Christy Gibson Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public, and for anyone who has seen information put out by this prosecutor in this case. A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Wagrowski took the stand and said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw. So he believed the parents arrived at the school together, and subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars met and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be. When Brian Maloche testified, another example came about where the prosecution had him testify that, with me, I'd rather do anything else. And we do spend time together, but that's not their first priority when they get to pick what they're going to be doing. It does not mean she loved her son any less if she ever told a witness, my son is weird. And part of what made me realize I could be in Mrs. Crumbley's shoes is I've sent texts to my husband saying, our daughter is a psycho today. On the way to school last week, she's crying, she doesn't have people to sit with at lunch. I texted him, she's a nutcase. I don't know what to do. I don't know how to handle this. I don't have time for this. My other daughter is complaining about her lights flickering in her room. I texted my husband, this sounds like a case. The start of a case. My husband works for my office. He's actually my office manager, so he knows about the case. He went in her room and figured out in 5 minutes, it's because when she flips her blow dryer on, one of our plugs makes the lights flicker. So this ghost that you would read about in my text messages, which by the way, I did not respond to, despite the fact that it's on our 6-person group chat, would be taken out of context and make me look like I don't really care that my daughter is crazy. I also got text one day, we have no food in our house. I am absolutely starving. You are the worst mother ever. And you know what I did? I ignored it. She was mad we didn't have the right kind of chicken ramen. When we have 85, I like the number 85, when we have 4 other flavors of ramen, and there's about 100 other things she can eat, and I knew she's not gonna starve to death, but taken out of context, it makes me look like a neglectful mother. But if you know all the circumstances, and you know the relationship I have with my daughter, I knew it was an overdramatic, stupid point. So when you see messages from Mrs. Crumbley's son saying, will you at least call back? Those are so out of context. And when I'm driving home from court every day, I'm getting messages, will you at least call back? And I don't, because I know what they want is for me to run through the McDonald's drive-thru and bring everyone a Coke. I do stop and get myself a Coke, but I am not getting a round of drinks every day for everyone, and I've realized it's easier to not answer the phone. So you can find reasonable doubt from the context that the defense did actually provide. And when Mrs. Crumbley got on the stand and explained to you her understanding of ghosts and dishes flying and laundry flying, that is evidence. And that is something that can create reasonable doubt to hear what was really going on. Even if you believe the prosecution's dates about what was going on, it's not strong evidence, it's very misleading, and I'm gonna go through what it does show. There are 3 sets of dates involving Mrs. Crumbley, all from March of 2021. The first time is March 8th and 9th. They introduced exhibits, including text messages on the 8th, where Mrs. Crumbley starts off asking, is he home yet? Is he home yet? I don't want him to do anything stupid. I'm sure you all remember those. Then they introduced evidence on March 9th that she went to the barn that day with her husband on the 9th. Then they introduced evidence, and I will give them credit, they put together quite a case, although it's really not important, that there was a picture of the horse taken at the barn that day, that the data supports there was a picture of the horse taken at the barn that day, and that there was GPS tracking information supporting that she was at the barn that day. Okay, fine. So on March 8th and 9th, there's concern that the shooter, Mrs. Crumbley's son is making weird comments, and on the 9th, she goes to the barn and she takes some horse pictures. That's all that shows. Pretty minimal. Next, they went to March 16th through 19th, which was broken up into a million exhibits that, quite frankly, were out of order, threw me off my game, helped create these beautiful TikToks, and I'm gonna tell you what they show. Now, these ended up all being admitted as exhibits, but I'm gonna go in order of what they show. There was a text thread in Exhibit 85, which if you wanna look at it, you can, where Jennifer Crumbley said, "I'm gonna get drunk and ride my horse." This was on March 17th. St. Patrick's Day. A lot of people have a cocktail on St. Patrick's Day. That does not make her a mother that would be negligent or grossly negligent to her child. There's text messages from the day before where Mrs. Crumbley's son is saying some things about, now the house is haunted. Some weird shit just happened, now I'm scared. I got some videos, a picture of a demon, it's throwing bowls. I'm not joking, it fucked up the kitchen, I'm going outside for a while. Can you at least text back? On that day, Mrs. Crumbley didn't text back, but their own exhibit, okay, which is Exhibit 83, so the numbers do bounce around, so we go from 85 to 86 to 83, show that within an hour of the shooter making these ghost comments, she did call him. Specifically, she called him back at 7:24, and they had a 19-second phone call. If it was 19 seconds, it most likely was, "I'm on my way home, we'll talk when I get home." So then the state, in order to make it seem like they've really, really got some proof here, they admitted exhibits 87, which show on the 17th on St. Patrick's Day, James was on a horse. They showed People's Exhibit 88, confirming the metadata that James was on a horse. They showed a picture, 89, of Jennifer on a horse that day. Metadata to prove she's on the horse that day. Another picture, number 91, of James on the horse, a different picture. The metadata to prove James is on the horse. A picture of Jennifer with her horse in Exhibit 93. And again, the metadata to support the picture was taken out of the barn and sent, and that these people talked about these horses. Okay, so fine, that's on the 17th of March. You're gonna have access to all this evidence if you wanna see it. Then they introduced exhibit number 86, which is where their son says the house is haunted. This is on the 17th. This is the day where he says, "Can you text back?" This is the day where I already showed you the exhibit. She called him. She didn't text back, but she called him. And then they show a couple texts from a few days later on the 19th, where it's obvious from the messages the Crumbleys had had an argument with their son the night before. He was upset to have his phone and things taken away, that Jennifer Crumbley gave him a melatonin to go to sleep. She should have only given him a half, it's in the messages, but she gave him the whole thing, and it knocked him out and he slept in their bed that night. And when he woke up the next morning, James described it in the text messages as he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer says, well, he was really worked up and out of control, so I can see why, talking about his behavior during the fight. All I know, Jennifer says, he needs to eat, go to work hard, not complain, and he can get his stuff back. She testified that getting his stuff taken away is his trigger. It's what makes him get upset. She says, you respond and I didn't get it. James says, Jesus, yes. He said, let me ask you a question. Why am I in your room? That's when they talk about the melatonin. She says, oh my God. James says, I really thought you were giving him a Xanax last night. Jennifer says, does he seem better? No, melatonin. James says, I know. So obviously he's joking. Jennifer writes, but he hasn't had one before, so I should have only given him half. James writes, well, he's doing his school, says his head's hurt, so he took Tylenol. Jennifer asks, is he okay to work? James says, yeah. Does he remember what he did? James finally says, dude, I'm working. I'm on a demo right now. I haven't talked to him. He's doing school. And that's really the extent of the conversation. So fine. So one day they get in an argument. And I'll tell you what, those kind of arguments in a heartbeat could have me sitting in her chair. The final date that the state claims Mrs. Crumbley had knowledge about back from March of 2021 are exhibits 96 through 100. And 96 starts off with their son saying, I'm picking up the room, I cleaned until the clothes started flying off the wall. This stuff only happens when I'm home alone. I pick the clothes back up though. And that's the important part of those texts on the 20th. We know on that date, because the people proved it, no pun intended, but they beat a dead horse, that at 97, it's a picture of Jennifer at the barn. We've got the metadata showing Jennifer was at the barn. We've got another picture on 99 showing Jennifer was at the barn. And exhibit 100, Jennifer was at the barn. Big deal. Jennifer's at the barn. Their son is saying goofy stuff. Jennifer gave you the context. They had an Ouija board for a couple months after Christmas of 2020. He and his friend are playing with the Ouija board. They ultimately lost interest. They stopped doing it. Jennifer admitted to you one day to mess with them. She turned the power off in the house, turned the circuit off to mess with them. She mentioned a time where James pretended he was getting electrocuted. She didn't know what to do. She's screaming, trying to kick him, see if he's electrocuted. Ethan is laughing, taking a video of the whole thing. This family played together. They had fun. They did what families do. The prosecution just had zero context because they had tunnel vision that she was doing something wrong and was grossly negligent, and they were hell-bent on convincing you that was the case. So the other thing that you can find as a reasonable doubt in the case is the lack of evidence in the case as a whole. The prosecution has made very serious claims. And when you really look at it, they have very little evidence. So what they've shown to you, and I have it in these folders, are these dates in March 2021, which, by the way, are 10 months before the shooting even took place. They're before it would have, it's unreasonable to expect that things that happened in March of 2021 are an indicator that 10 months later their son's going to do something. It would be very different if every week there's something going on up until the shooting, but there's not. Because if there was, the prosecution would have brought that in and showed you every horrible thing that was happening to show you their son was being ignored, and they don't have the evidence. So what they did provide and what was admitted, this is exhibit, I believe, 423. These are all the Facebook messages between James and Jennifer. So when you look at those Facebook messages and consider, and this includes the photographs and the GPS stuff, that they're using this much compared to this much over the period between January 2021 and the shooting. This is a very little bits in time compared to the grand scheme of things. And while the officer testified and played games with me that he's not sure this is the best evidence against mother, you better believe if they had better evidence, they'd be up here showing stronger and better evidence. This is it, ladies and gentlemen. It's obvious from the evidence in trial, and you may find it to be a reasonable doubt, that the Crumbley son was a skilled manipulator and they didn't realize it. He's not sick. He doesn't have a mental illness. He's had no history of hallucinations. He has never shown his parents signs of mental illness. He certainly never showed signs of mental illness wanting to get a gun. No parent would purchase a weapon if they believed their child had mental illnesses. And these are people that had 2 other guns in the house for months where nothing ever happened with those guns. They had no reason to believe that somehow this 3rd gun was the thing that was going to make the difference. The texts that the prosecution admitted as Exhibit 101 were texts between the shooter and his friend that we have not named. The extent of these text messages saying goofy things like, I told my dad to take me to the doctor, he gave me pills to suck it up. It's at the point I'm asking to go to the doctor. I'm having insomnia and paranoia. I'm calling 911. I thought about calling 911, but my parents would be pissed. I don't disagree with the prosecution that these are alarming messages, but clearly the shooter's friend isn't that alarmed because he's not texting back. The shooter's friend knows there must be more going on because he doesn't tell Mrs. Crumbley, who is like, he's like a second child to her. And we have no other context about these messages. And if anything, the evidence does not show that Mrs. Crumbley ever saw these messages. Now, when she sees them now, she thinks, that's crazy. She'd like to know more context. But you also have to know, and another reasonable doubt you may find in this case, is created when you compare these text messages that were sent that have alarming things between Ethan and his friend to all of the messages between them, which are over 20,000. And what you would have to believe, and what I would believe, is that if the state had stronger evidence, they would have paraded it up and we would have been seeing a lot more of these. But instead, they were admitted, and you haven't heard the friend testify, you haven't heard any context about these, and all you can see, and really all the evidence shows, is that there's no reason to believe Mrs. Crumbley ever saw that. I don't want to have another Leaning Tower of Pisa situation, so move this down.
I'm watching it.
You did? I've taken your advice. Now, the other evidence the state has shown are little bits and pieces from the shooter's journal that are quite alarming and disturbing. But again, Mrs. Crumbley says the information in there about my parents won't listen to me for help is not true. And there is no evidence to show she ever saw that 22-page handwritten document. She never saw the little bits of evidence that the prosecution admitted. To evaluate this case, you have to look at it from the perspective of what she knew. So the journal information and the small amount of text compared to all the text with his friend are things she didn't know about. There's also 2 times where the state says that they have proof that Mrs. Crumbley's son was showing signs of depression or being sad or lonely. All right, those come from April 29th, 2001. This is when Jennifer Crumbley emails the friend, his mother, and all she says is that her son has been acting kind of depressed. She doesn't know what's going on. She's trying to find out what's going on, but he won't really tell her much. She's trying to find out if there's an issue between the two boys she should get aware of. She's trying to get down to the bottom of it. If anything, she's doing what a good mom does to try to figure it out. But the worst of what she says is that he's stressed by school. I don't want to get this wrong. He's been acting kind of depressed. And she's happy to hear it's not an issue between them. Then they go on to make plans for their son. This was admitted as Exhibit 104. If you put my text up there and showed every time I told my mom that one of my kids was acting depressed or weird, I guess my favorite word is moody these days, it would look like my kids were complete lunatics. I'm actually shocked Jennifer Crumbley doesn't have more texts about her son acting like a typical teenager. And Jennifer Crumbley testified that although she said that, she didn't think it was anything she needed to run to a doctor about or anything she needed to do anything more with. And this moment passed, because if it didn't, the prosecution would have brought in all the texts that went beyond this, and there would be more evidence. They also brought in texts with the same parent of the friend from Exhibit 105, the friend's mother, when Jennifer Crumbley reaches out to her saying she had no clue what they were going through with their son, and she felt really bad about it, and asked how they're all doing and that they're thinking about them, that family, a lot. And ultimately, the worst that Jennifer Crumbley says about her son is, I know my son misses him. And if you need anything at all, don't hesitate to ask. That's it. It doesn't go on with wild depressions or hallucinations or mental health issues. That's it. That's it. I'm actually shocked there's not more instances of depression or moodiness or my kid is acting weird. The fact that there's this little evidence is shocking to me. However, it's a lack of evidence on the state's part. There's also a lack of evidence in Mrs. Crumbley saying he's depressed to really anyone else. Even after the shooting, when she's talking to her friend Kira, to other people, to Brian, all she keeps saying over and over is, I wish there had been signs. I wish there had been something. He's a normal kid. There's a complete lack of evidence of mental health concerns specifically. If you want to really spend some time digging into this, you can read all the messages between James and Jennifer Crumbley, all of them, and you will find that there are not texts that go on and on that their son was exhibiting anything close to a mental health concern. And again, my text would read worse because I say things like, I think my daughter's psychotic. When Mrs. Crumbley did have to evaluate what's going on with her son and there was something alarming happening, she relied on people who spend day in and day out with kids, people she considers to have more expertise in kids than she does, including Pam Fine, who left her a very nonchalant voicemail that you've heard. It was Exhibit 115 if you want to hear it again, saying Ethan was looking up bullets in school today. It's not illegal, it's not wrong, he's not in any trouble. It's just like how teachers can't look up hops for beer. You don't need to call me back. She was relying on the representations by the school counselor, Sean Hopkins, who took the stand and has had a lot of training, hundreds of hours of training, and made it very clear this was just an issue where he needed some kind of therapy and didn't think it was necessary to suggest to the Crumbleys, go to Common Ground today, or serious enough that he called 911. And she relied on the assistant dean, who also has an abundance of experience Mrs. Crumbley doesn't have. And quite frankly, my kids didn't come with a handbook, and my guess is her son didn't either. And the assistant dean said the same thing in the meeting with Mr. Hopkins, that Ethan Crumbley that the son could remain in school that day, that he would probably be better off, according to Mr. Hopkins, around peers versus being alone, and that as long as they got him an appointment within 48 hours for some kind of counseling or therapist, that was sufficient. So it's absolutely not credible when a witness from the school, like Mr. Hopkins or Mr. Ejak, gets up on the stand and says, even if a kid is very sick, we cannot force them to go home. That is not true. And as parents with common sense, you should know that's not true. Because when my kids are puking, my kids' school will not let them be there. And when they have a temperature, not only can they not be there, but my children's school is always nice enough to remind me they can't be there for the next 24 hours, which means they can't be there the next day either. So reasonable doubt can be found in the fact that trained professionals told Mrs. Crumbley her son was not a risk, and Mrs. Crumbley relied upon it. This school also failed to even really look at the situation and tell her about things from the year before. They made it very clear that he was not in any kind of discipline issue, which is shocking to me and was shocking to Mrs. Crumbley, considering he's off topic looking at bullets in school. He's looking at a video in school of some kind of violent pictures, and then he draws a gun on his math paper instead of doing the math paper. So when school officials say, okay, this is really not a big deal, all we want is a counselor within 48 hours, Mrs. Crumbley took that as a very strong sign that things were fine. And reasonable doubt can come from the fact that those three people at the school, Fine, Ejak, and Hopkins, are mandatory reporters by CPS who would have reported if they thought Mrs. Crumbley or Mr. Crumbley were neglecting their son. Mrs. Crumbley even commented to others about the nonchalance that was at that meeting, that it was only 12 minutes long, which surprised her, that she was disappointed they didn't take it more seriously, that she was surprised there was no disciplinary action, and she left the school actually feeling better that maybe she had overreacted when she flew over to the school. Now, the people who are trained in these areas, they didn't just say, we're not trained in these areas. They gave specific examples. They said that kids who are really a threat, they would show nervous behavior. They would show anxiety about somebody else handling their belongings. In this case, the shooter was cool as a cucumber as Mr. Ejak went down, got his backpack with the gun in it, and brought it to him. And Mr. Hopkins and Ejak said they hoped they could get him into counseling today, but ultimately said he can stay at school and we'll give you 48 hours to get it situated. All right, so the prosecution keeps harping on the fact that Mrs. Crumbley knew they had bought a gun and that the people at the school didn't. This is Oxford Community Schools. These professionals testified about how common guns are at the school, so common, and this kind of blew me away, although I live out there, that students are known to go to the gun ranges often,
that girls on homecoming wearing their short little party dresses they wear to the dance take photos before the dance holding their guns, that kids go hunting on late start Wednesday before they go to school, and the school has to give reminders to parents for people to leave their guns at home. So this school that obviously has a strong gun culture going on, that sees a student looking at bullets, looking at a video game type thing with violence, and seeing a gun drawn on a paper, that these school officials, knowing that community, that they didn't ask if he had a gun when they carried the backpack down, and did make a comment about how heavy it was, although the comment evidently was made to a different teacher, and I misunderstood and thought it had been made to the shooter. So yeah, Mr. and Mrs. Crumbley, they didn't mention the gun, but they did mention that they had been at the shooting range with their son. And this is a community that is so into guns. I can't even believe that these girls, I always look at those pictures on Facebook and think, oh my God, how short are those dresses? And these are girls showing their dresses with their guns in their hand. They know this is a gun community. Reasonable doubt can be found from the fact that the biggest concern at the time was suicide and not homicide. The worst case scenario that was presented would lead a reasonable person to believe there was a possibility of suicide, not homicide. The prosecution seemed to also carry on about the amount of money and time that Mrs. Crumbley spent on horses. Just because she spends money and time on horses doesn't mean she doesn't love her son. And the fact that they have to stretch so much can create reasonable doubt. And if you actually look at the exhibits the defense submitted, you'll see that Mrs. Crumbley said she has to get a second job to pay for the braces, which are very expensive to put on her child's teeth. She paid for her son to be a part of a bowling team. She paid for him to do other sports. She cared about her son. Just because she cared about horses and bought medication from them and had a horse hobby, that's not any different than a dad who likes golf and buys new golf clubs and has a membership to a country club and spends time there and spends money at the bar there on days they go golfing. It's not any different. To try to suggest that it shows the priorities were on horses and not their son is just garbage. This is a son who had everything he needed and all kinds of opportunities in life. A son they take camping and on vacation to Cedar Point. Not only do they take him, they take a friend with them. These are parents that clearly love their child. They're sitting there playing board games with him, spending time doing that. That's all in the Facebook pictures that were admitted. Those are submitted to you as exhibits, and you can take a look at them if you want to. Brian's testimony in this case absolutely creates reasonable doubt. When Brian Meloche testified, there's no question he was inconsistent. And I would submit to you that there was no reason law enforcement needed to interview him for 2 hours, 1 hour, and then 3 hours. But over time, the police certainly caught on to the fact that the more you ask Brian the same question over and over and he realizes he's not giving the answer you like, he changes it. And while the prosecution tries to make it sound like, well, he didn't want his affair outed, from the very beginning, he told them he was having the affair with Mrs. Crumbley. That was not something that ever changed. It wasn't until the third interview when they started talking about his pension, talking about his job, that he felt pressure. He agreed with the word pressure, and he agreed with the word veiled threats, although he did take it back later, that the police wanted him to say something bad about Mrs. Crumbley. And I would submit to you that they probably did that to all of the witnesses in the case. But Brian Maloche was the one who admitted to it. And when Mr. Keast got back up there and asked him more questions, Brian got right back in line like he was supposed to and told them exactly what he knew they wanted to hear. Brian is a terrible witness. He said he had memory problems. And quite frankly, when he's testifying that he knows that the gun was in the car that day of the shooting, we all know no one thinks that's true. Mrs. Crumbley testified and explained the day the gun was in the car. Brian's just wrong. And when Brian testified that Brady was gone and he believed Brady died or committed suicide, I would submit to the jury that Brian is just an idiot and has no clue. And that the truth is, he didn't know the details about where the shooter's friend went. He just knew he went away. Wherever he got that suicide idea from, who knows? The prosecution didn't show any texts or anything to support that. But it's clear that Brian Maloche has been put on a mission, which is, you're coming into court, you've got some things hanging over your head, and we want you to take a position against Mrs. Crumbley. And I would submit to you that if you read the 77-page exhibit that I got yesterday and went through in painstaking detail with you, you can see that Brian Maloche did not think of Mrs. Crumbley that way when he knew her and when he dealt with her. And he testified the only places he got new information about her that made him think differently about his answers were from law enforcement and were from the media. The media that we have talked about in this case repeatedly as being inaccurate. Brian admitted that when the prosecution asked him, and we've already talked about this, to delete his messages, when I went through the part about clear the cache, Jennifer telling him clear the cache, showed him the stuff before and after, he realized it was just to refresh the page to see if Facebook had deactivated. So giving him little bits of information is particularly dangerous because he's not the sharpest. And that's what the prosecution did. They used him to their advantage to try to make it sound like they have this case and all these horrible statements against Mrs. Crumbley. And by the way, when they presented evidence that Mrs. Crumbley is deleting texts and keep making it sound like she selects different texts here and there, it actually sounds like Mrs. Crumbley deletes all her texts, as she testified, that when people start flooding her with text, she deletes entire threads at a time. Who knows what she's deleting? We saw her on her phone flipping through them super fast. And the texts ultimately that she deleted, the prosecution did point out two of them in their closing. They pointed out the texts about we're fucked and we're on the run again, but they didn't mention that she deleted two texts that are actually very exculpatory and helpful to her. Why would she delete some of the most helpful and exculpatory things she said? Those two texts are on page 42 and 44 if you want to see them in the 77-page exhibit. And those two texts confirm, she calls it the string lock was on the gun. She means the cable lock, but she doesn't know enough about guns to say cable lock. The string lock was on the gun. And the other deleted text that the prosecution didn't mention was when she said that the weapon had been locked, the ammunition had been stored separately, and that everything was not loaded. There's no reason she would delete two messages that are that helpful to her. She's just a person who deletes all of her messages, as she testified to. You can find reasonable doubt that Mrs. Crumbley's state of mind is very obvious in statements she made after the shooting. Right away, she's talking about how she had no signs to believe anything would happen. At the substation interview, it's on recording, we watched it. She tells the interviewer, I had no signs, there were no signs. Then when they have her in the car, the squad car, and she's in the back, she says to them again, I had no signs. In her text message with Kira, which was admitted, she says there were no signs. Kira says there probably were, you just missed them. With Brian Maloche, Mrs. Crumbley says again, there were no signs. I would submit to you, this is not some master plan where Mrs. Crumbley decides she's going to suddenly say there's no signs. First of all, there's no evidence of signs Mrs. Crumbley knew about. And second, all of her immediate fast statements in a time of stress went right after she's had guns held to her face, walking out the front door of her house. She's saying there were no signs. You might find, and I know the prosecution takes issue with this one, Mrs. Crumbley was actually, in fact, a hypervigilant mother. She's the kind of mother who is going to the friend's mom to chase down why he's having a moody and kind of depressed day. She's on Power Schools on the app multiple times a day checking for missing assignments. She's emailing teachers about grades. Christy Gibson Marshall, the assistant principal who did do one of the bravest things I've ever seen, she testified she saw the shooter's face and couldn't believe it was him. And the reason she couldn't believe it was him is because it was so unforeseeable. Mrs. Crumbley's hypervigilance also comes when you look at how she takes him for medical appointments. They're at the urgent care because some little mole on his back changed colors when she's applying sunscreen. I think of myself as a hypervigilant mother, and I've never noticed any moles on my kid's back, and I must need to go home and look. Because when I look at the actions of Mrs. Crumbley, she actually pays far more attention to that kind of thing and other things than I do. I could easily be sitting in her chair. When her son's experiencing headaches and medical issues, she's at the doctor or doing virtual visits. There's no reason to believe that's not true. With the headaches, they go through a whole process. She gets a whole x-ray done of his head. She takes him to the eye doctor to see if that's causing the issue. Ultimately, she pays and puts braces on his teeth. Then, he's a bad brusher, so she's going to the extent of getting the braces off his teeth so he can get the cavities fixed, 13 cavities. I would go crazy on my kid. And she's just doing each thing she needs to do as a hypervigilant mother. And yes, a hypervigilant mother can have a drink once in a while. I'm a hypervigilant mother, and I not only have a drink once in a while, but sometimes I've been known to have 2 or 3 or maybe a bottle. Reasonable doubt can be found from the fact that Jennifer Crumbley did her best as a mother. While going to the shooting range is not her thing, she's trying to find a way to bond with her son, who has just had his best friend move away. She took him camping, took him on trips, brought the second son along like I've already talked about. She let him have pets. He has the cutest little kitten you've ever seen in these Facebook pictures. Board game nights with him. She's not neglecting him in any way. And if anything, she's going to the gun range for him, not because she enjoys it. You can tell how much she loves it when she gets up there, shoots a couple shots, and then just stands there letting him enjoy the activity he likes. And I do the same thing for my kid. He likes to go to skate parks. I would rather do anything but go to the skate park. But I sit there and watch and say, oh, that was amazing. And all I hear is, Mom, watch this. Mom, watch this. Mom, watch this. And I would rather do anything else. But Mrs. Crumbley on that day is trying her best to bond with her child and have a relationship. Showing the pictures of the messy house was just not necessary. And the prosecution explained to you they weren't trying to prove she had a messy house, but much of it was just so unnecessary that I would suggest they are trying to make her look bad. They do kind of make her look a little bit like a hoarder.
But if you saw pictures of my house right now, like a snapshot in time, you'd be just as horrified. I've been so busy getting ready for this trial, ready for all the fun we've had in the court and through these last few weeks. I still have my Christmas trees up. I was complaining to my husband the other day, oh my God, we still have our Christmas trees up. This is embarrassing. And he said, hey, Shannon, we still have ceramic pumpkins up. And I realized, oh yeah, all of our fall decorations are out too. And right now I have piles of laundry all over. My kids over Christmas break put together stacks of stuff I need to take to the Salvation Army. I have donations of my own that need to go. My house right now, if they did a search warrant today, would look just as bad as Mrs. Crumbley's, and it says nothing about me parenting my child. If anything, when I come home from work, I make a deliberate decision. All right, listen, I can run around this house for 3 hours and try to get as much as I can done, or I can sit on my couch and watch old episodes of the Kardashians with my daughter. And I believe my time is better spent hanging out with her watching trashy TV than cleaning up my house because I get a chance to spend time with her. And Mrs. Crumbley was the same kind of mom. She was waiting until the holidays to have more time. She said she was going to clean her son's room. I would be screaming that I would make my son clean his room, but regardless, the project coming up was going to be to get those rooms in order. But at that point in the year when the holidays are coming up and you're getting ready for all of it and going through Thanksgiving, it does get to a point where you do have boxes piling up and you're just trying to get through those last days of school to get to Christmas break. There's reasonable doubt when you look at what Mrs. Crumbley thought after the meeting with Mr. Hopkins and Mr. Ejak. The state of mind she was in and her thoughts and what she was thinking come in through her statements. She thought everything was way less of a big deal when she left that meeting. She thought leaving him in school with his friends was the better decision based on Hopkins saying peer support is a good thing. She thought making him an appointment was sufficient within 48 hours was sufficient. That doesn't even mean the appointment was going to be within 48 hours. Reasonable doubt can be seen in the video when Mrs. Crumbley first sees her son at the substation. Her reaction to seeing him in this complete state of disbelief as to what's going on is to look at him and say, why? Why? She doesn't look at him and say, I knew you were going to do this. She doesn't look at him and say, see, I knew we shouldn't have bought that gun. She says, why? Why? And when he says, take care of Dexter, she cannot believe that's her son and goes back into the other room with her husband and says, what the fuck? He didn't even care. And while the prosecution asked questions about, well, she's not sobbing and we hear sobbing, and that's clearly James. James is sobbing. When you look at the video, if you decide you need to see it, Mrs. Crumbley is dabbing her eyes and wiping her eyes. And fine, she's not the crier some other people are. Reasonable doubts can come from the statements in the heat of the moment at the substation when Jennifer Crumbley is in a state of shock trying to answer their questions. She says, he's never done anything bad. This is after she already has somebody saying you really should have a lawyer there. She's still just talking about what the truth is. He's never done anything bad. One of the parents says he's a perfect kid. Jennifer Crumbley tells them the most of an issue he ever has is anxiety over tests. Jennifer Crumbley tells them everything was fine this morning. In the statements Jennifer Crumbley made when she was in the car and doesn't even know yet if there has been fatalities, she says he's never done anything. She acknowledges he ruined lives today. She says, it's the first time I've ever seen him do anything. She says he's a good kid. He's never angry. He's mellow. He's not what he looks like. He's not a monster. And she's not a monster either. She explains to them in detail when they ask, he's never had mental issues. In those moments, she can't even think straight about life around her. She's worrying about a horse and her job and all kinds of random stuff. And ladies and gentlemen, when emergencies happen, life doesn't just stop. So the fact that she's able to function and think, I still need a job, I need some money, I need a phone that works, that doesn't mean she thought her son would terrorize and kill people and shoot people at a school. Her reaction when she finds out there are fatalities was genuine and honest, and she broke down crying, although she does continue to keep answering their questions. She explains why she feels like fatalities are different. She explained that on the stand. If he had shot people and injured them, it was something they could at least deal with. But a fatality is a fatality and can never be changed. The prosecution's attempt to misconstrue Jennifer's entire demeanor is a reasonable doubt in this case to show they don't have a strong case. They keep saying she's not sad. Jennifer explained she went into what can I do mode. She did show sadness if you read the texts between her and Mr. Maloche. She showed sadness in the way that she shows sadness. And for these officers to get up on the stand and say she didn't behave like the mother of a school shooter should behave is nonsense. None of them have ever dealt with the mother of a child a teenager who has just killed people and shot many others. There isn't a right way in any handbook to say how you should or should not behave. Trying to make her look selfish and callous goes right with that same thing. How she reacts is how she reacts. You see it on the screen. It's really hard to pass judgment, although these police officers did, on how a person should react when for the first time in their lives they walk out of their house and are surrounded with guns in their face. Or how a person would react to be woken up in the middle of the night on a mattress with police around them and above them with guns in her face. So not only has anyone not been in the shoes of a school shooter and dealing with the kind of emotions that would come with that, they also don't know, and there isn't a standard reaction for how you behave when you're surrounded with guns in your face. Jennifer's own statement provides reasonable doubt that she didn't think he would hurt other people. She typed to him, Ethan, don't do it. She didn't say, don't shoot people. She didn't say, don't hurt anyone. She thought the only thing on her radar that could be possible at that point, knowing there's an open shooter and he has a weapon, was that he would kill himself. Reasonable doubt can be found in Jennifer's testimony. Jennifer's testimony is evidence, and at the end of the day, whether you believe, like, hate, however you feel about her testimony, the defense didn't have to prove anything. You still have to evaluate the prosecution's case for what it was. However, Jennifer Crumbley did take the stand, and that was not easy for her, to give you additional context about what was going on in the shreds of evidence the prosecution cherry-picked and put before you. The only person who's actually been consistent in this case, and you can find reasonable doubt from this, is Jennifer. She's consistent in what she says to police, what she says to her husband about things, and what she says to other witnesses who testified.
You can find reasonable doubt in the fact that the police officers are very, very biased in this case. There is no doubt this is one of the most awful situations any one of them have ever been involved in. But it's also very clear they have a narrative that Jennifer Crumbley is responsible, and when they came in here and took that witness stand, they were gonna mess with me on questions that were so stupid. Like this ATF agent telling me he doesn't know if teenagers could lie. Everyone in the room knows a teenager could lie. That was a lowball. Just answer the question. When you have an ATF agent that can't even get on the stand and answer a question that's common sense, that should speak volumes. That there's a narrative they've been directed to get out and they have an agenda. And that agenda, ladies and gentlemen, is not positive for Jennifer Crumbley. Making this big deal about money and cash that Mrs. Crumbley took out is another reasonable doubt in this case. Mrs. Crumbley explained her dad had accounts frozen. She didn't want her accounts to be frozen. Her dad put money in that day so she could take it out. Getting money out of the account that had her son's name on it wasn't done in any way to steal money from her son or show she doesn't care about him. She's the one that contributes every week from her paycheck into that account. And at the end of the day, she wants cash because everyone in the world absolutely hates her. She can't walk in places and hand them a credit card. Hey, Jennifer Crumbley's on that credit card. The only option she had was cash. She can't go in and start showing identification and things to get hotel rooms, and the more cash she can use, the better. The less she has to risk that people are going to figure out who she is. And remember, the world was essentially showing its colors against her as she was receiving threatening messages in the days that followed that shooting. On Facebook, from other people, in her emails, in her Instagram, everywhere. They're so threatening, her employer is making her shut down accounts. Her friends, people that have been her people for years, don't want anything to do with her and don't want to be by her because she's that dangerous at that point in time. So for her to want to have cash makes absolute perfect sense. That's not a sign she's trying to flee. And also, if you're trying to flee, you don't go around local Oakland County and areas surrounding it and carry around a syringe of horse medicine. If you're gonna flee, you abort mission on the horses. At that point, you're fleeing. It's very obvious Jennifer Crumbley, her intent was not to flee. Her intent is to stay safe. Her intent is to avoid threats. Her intent is to get this horse medicine to this horse, which obviously can't happen if she flees. It's clear when she's at the art studio that she's not hidden very well. She's outside smoking, her husband's outside smoking. We saw the evidence of the cigarette butts in the snow. There's commercial buildings around and businesses within that studio. She's walking around taking a tour of the studio with her friend who owns it, and there's cameras all over the building. Obviously, she's not trying to hide if she's going into a building where you can see security cameras right on the outside that would document everything that's happening that we ultimately got to see in this trial. It's clear she's trying to stay the night in Detroit on November 3rd and didn't know where to go. It's clear from the video she's dead asleep at 1 o'clock in the morning when they're ultimately found and woken up to guns in their face. She testified she took 4 Xanax, and so did her husband. We also saw evidence there was a liquor bottle in the garbage, and presumably she had a drink. After 4 days of no sleep and not really eating, one can only imagine how hard 4 Xanax and a cocktail might hit you. So they make this big deal that there's text messages after 11 o'clock saying we might have been found. Well, earlier in those text messages that were admitted by the prosecution is Exhibit 430. The first text says, Marielle, this is Jennifer's phone. And Marielle was the other attorney at the time. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. Next message. The other phone broke. And then there's a message to the Crumbleys, when you can, we'd like for you to call us. That's at 6:19. Then at 6:21, thank you, Shannon's calling you both shortly. Then at 7:02, I text, Marielle and I are going to come get you in the morning. We do not think it will help to make a statement that you're coming in or that it will be tomorrow morning. All we can say, as we've told everyone, is that you're coming back, and as of tomorrow, you'll be back. My next message says, we can show them that everything we've said was going to happen did happen. Because the Crumbleys weren't running. They just wanted to turn themselves in to a court. And law enforcement got on the stand and told you that's something people commonly do. It just didn't happen in this case. At 7:03, the Crumbleys write back, and we don't know if it's Jennifer or James because they're sharing this phone. Okay. Text to the lawyers that say Marielle, Shannon lawyers. Who knows why they sent that? I text, I am going to drive home from my office right now. I'll give you a call in about 45 minutes so I can get all of the bond factor information written down for you for Marielle and me. I'm asking for bond information so we can go to the court in the
Your Honor,
morning.
I'm gonna object. There's a prior ruling. She cannot be a witness. That was already dealt with.
Sorry, I thought I was arguing off the evidence they admitted.
Well, you can argue off the evidence. But
Okay. So they say at 7:37, okay, we'll be waiting. I'm gonna call in 1 minute, okay. Then at 11:14 on the phone that both of them have been using, a text is sent to the lawyers, think we might have been found, don't know, just a heads up, please check. It's not for a couple hours that they're actually found, but Mrs. Crumbley testified she didn't send that text and she was already asleep. Now, after those text messages, there's 2 more pages that are included in that exhibit. So if you do end up taking a closer look at 4:30, which is totally fine, just be aware that there's another thread that starts that's a repeat, and I don't know why that is. I just want to let you know that, and I'm not sure why that exhibit is like that. That was a new one we got, obviously, all today. In the days after Mrs. Crumbley and Mr. Crumbley are planning to turn themselves in. We know they're planning to turn themselves in because Exhibit A was admitted, which showed they were trying to find a hotel in Auburn Hills on Priceline for December 4th and 5th, in case they needed it for the weekend. There's no doubts, and I don't need to go on and on about this, they were getting threats. That was so clear at trial. They were afraid to go turn themselves into a police station. A police station where if they went, there would likely be other inmates or bad people there, and their faces would be up on a TV because it was all over the state at that point. They were terrified. They wanted to go in through a lawyer. Reasonable doubt can be inferred from the fact that they set an alarm clock, which was admitted by the prosecution, showing that on Saturday they were getting up at 6:30 or 6:45, completely consistent with their plan to go to Novi for an 8:30 hearing. This is also not James's trial. I am not standing here suggesting that James is guilty of involuntary manslaughter in any way, but it is important to point out that James was the parent responsible for all of the storage of the guns. Jennifer Crumbley barely knew a thing about them. She didn't object to them being in the house. She didn't object to buying the gun that James and Ethan were interested in. She didn't object to calling it Ethan's Christmas gift. She was not responsible at all for the storage of the weapon. It is misleading to suggest by the prosecution that that 6-hour case was open on the bed and that it sat open like that all day with the ammunition box next to it. It's very clear that when James and Jennifer Crumbley were on the phone during that 7-minute phone call, Mr. Crumbley was looking for the gun, found the gun was missing, asked Jennifer Crumbley, where's the ammunition, pulled it out, and set it on the bed. It's not like that gun box, that case, was just sitting out there open at all times. When law enforcement did get there, find it on the bed, even they moved it around to the kitchen counter and other places. While this is not James's case, it is fair that Jennifer Crumbley would expect that he would have more flexibility in going to handle an issue at the school. That is not unreasonable and does not make her a bad mom. He's out in the Oxford, Lake Orion, Rochester area door dashing. She's the one with a professional career supporting the family and paying all their bills and trying to keep her job, which they may need to add the family on for insurance in this open enrollment period. She shouldn't be diminished as a mother because she was going to let father go to the school and handle whatever issue there was. Now, ultimately, they went together, but he's a DoorDash driver. She's trying to pay the bills. She's the breadwinner. At that time, he's in between jobs. She shouldn't be dinged for that. It's misleading for the prosecution to suggest there's been evidence in this case. She keeps guns in the car. She didn't say she keeps guns in the car. When she was interviewed, and if you really want to watch the interview, you can, Jennifer told law enforcement there was one time that gun was in the back of her car. That one time was when James put it in the back of the car, and she drove the car to the range. Her son and her had an experience at the range, and she drove the car back home, left the car locked with the gun in it, so that when her husband got home, he could put it away. It is not true that she was driving around keeping guns in the car. That is not what she said to police. As far as Mrs. Crumbley knew, there was a cable lock on the gun at all times. She called it a string lock. She testified that the key was kept in a separate place in one of the many beer steins they had. She testified that she did know where the ammunition was. She hid it in her drawer of jeans. And she testified that things were locked and hidden separately, and that Mr. Crumbley was responsible for hiding the weapon. If you are upset with how the weapon was hidden, that's not your issue to decide. That's a future jury that will look at the case of James Crumbley. You're here to look at the case of Jennifer Crumbley and consider what she knew. She is not the person responsible for storing this weapon. I'm not trying to suggest she didn't know it was in the house, but she is not the person putting the cable lock on and off or doing anything with the gun. We saw her gun abilities when she went to the range and had to have her son show her everything about it. It's a gross overstatement to keep saying that the gun was his gift. It's very clear it was something bought for him to use at the shooting range, something that may one day ultimately be truly just his. But it's just like any of us giving our kids a laptop to use, a cell phone to use, a car to use, a jet ski. I have a friend that has kids, they have snowmobiles. Nothing different. It doesn't really mean the kids just have free access to all of that stuff. It comes with conditions, rules, and parameters. Unfortunately, this is a case where the prosecution made a charging decision way too fast. It was motivated by obvious reasons for political gain and media attention. And we know that because on 11/1, when the shooter was arraigned, the shooter was on Zoom, and so were the parents, and the media was aware. And when Mr. and Mrs. Crumbley were charged, and there was a swear-to at the court, the media was all there, but guess who wasn't? Mr. or Mrs. Crumbley. Mrs. Crumbley testified she didn't even know there was going to be an arraignment, but the media knew. And then the prosecution came out with a big press conference, announcing it. I would submit that the plan was never to let the Crumbleys turn themselves in, but to turn them into a big charade of looking like they're trying to flee when they absolutely weren't. The prosecution and law enforcement have approached this case with tunnel vision from day one. Brian Maloche called it a witch hunt. I would submit to you it was. And once they charged these parents and the ATF, Sheriff's Department, Border Patrol, Secret Service, all U.S. Marshals, not Secret Service, when all these agencies have gathered around and hundreds of people are looking for the Crumbleys, it's really hard to say, we made a charging decision a little too fast. And in this case, you heard evidence that much of the evidence in the case didn't roll in until after the parents were charged, arrested, and in jail. To try to suggest having multiple phones as a sign of fleeing is just garbage. I think everyone here clearly understands why they bought burner phones and why they went and bought replacement phones with their phone numbers so they could use two-factor authentication to get into their accounts. Jennifer Crumbley is seen in the police interview at the substation handing her phone to law enforcement when they're asking questions. When the police tell her they want to take her phone for a search warrant, she doesn't want to hand it over right away, but it's not because she's trying to hide things. It's because it's her only line of communication. She doesn't really understand how a search warrant works until her husband explains it. All of her contacts are in the phone. She doesn't carry around a little diary of all the numbers, although police do let her get the numbers out. And it's the only way people can get a hold of her, and she's been in touch with them nonstop, as we can see when she's in the police vehicles. And again, although she's on her phone, and there is a substantial amount of time where she's looking things up, communicating with people, trying to get things done, that doesn't mean she believed her son was a school shooter and had no emotions over what was happening. The prosecution has painted her out to be a person who lacks remorse, and I would submit to you that she would change everything if she could. And when she looks back and says there's not a thing that she feels she could have changed that would have changed something, you have to keep in mind that the suggestions by the prosecution are just ridiculous. Giving him a hug that day in the counseling office was going to stop a mass shooting? That's just ridiculous. There is nothing to prove that anything could have stopped a mass shooting when you're dealing with someone who is so manipulative and is a criminal and was a shooter in cold blood and pled guilty and took responsibility as an adult for his crimes. Finally, my last reasonable doubt card is blank, because I've tried my hardest to come up with all the reasonable doubts the defense sees in this case. And like I said, each of you need only one to vote Mrs. Crumbley not guilty. But a lot of times jurors think of a reasonable doubt I miss because there's so much evidence. And we've already established, and I've admitted I'm not a perfect person and not a perfect lawyer. So I put a blank card before you so that if you have a doubt I've missed, you know you're not limited to what I've suggested or the defense has suggested. You're welcome to come up with your own doubts on your own. And if you decide you want to dive in and read the truth between Mr. and Mrs. Crumbley and everything they talk about, you're totally more than welcome to. Those exhibits are all going back with you. And what I'll tell you is that you're gonna find a lot of instances where Mrs. Crumbley is anxious, asking where her son is, where her husband is. You're gonna see a lot of horse talk. You're gonna see arguments between a married couple. When I read them, they read just like my husband and myself, yelling and swearing at each other at times. And then the next message says, hey, what do you want for dinner? And then we just move on, and that's just how life is. You'll see messages in here that will certainly make you blush when you read what Mr. and Mrs. Crumbley intend to do in bed that night. You will read a variety of messages that show real life and real life between two married people that have a child. And it should make no difference that they may use their horse's name more often than their son's. And I'd also submit that every time you see them talk about when is he gonna be home and what are we gonna eat for dinner, even if they don't use the words spelled E-T-H-A-N, that's who they're talking about, because there are only 3 of them in that house. At this point in the trial, I am asking that you find Jennifer Crumbley not guilty, not just for Jennifer Crumbley, but for every mother who's out there doing the best they can, who could easily be in her shoes, for every parent doing the best they can, who could easily be in their shoes, for every parent that has snippets of text messages that could be read and make them look like horrible monsters, for every parent that has fights with their kid on text message that also could make them look like terrible parents, for every parent that's ever had a hobby and has not spent 24/7 with their child. That should not be held against parents. For any parent that's ever had an affair or spent time communicating on an affair, that says nothing about how much you care about your child or your expectation of whether or not they would commit a school shooting. Most people who have affairs would still not expect their child would do this. I do wish more than anything this case could bring justice to the victims of the shooting, the victims of the terrorism that took place that day, and the victims of their families. I wish more than anything it really could be a result that would be a Band-Aid to make everyone feel better, but it can't be. First of all, it brings back nothing for the people who have lost. It certainly doesn't bring back any lives. And if anything, this is not justice. This is not how justice works. This case does nothing for the people who have already lost everything. Many of the people sitting in this courtroom. And it does nothing to bring back the tragedy and the tragedy that unfolded on November 30th. At this point in time, the prosecution cannot prove that Mrs. Crumbley avoided exercising ordinary care that would have saved lives. The prosecution cannot prove that Mrs. Crumbley was aware there was a danger that existed by her son that required her to exercise reasonable care. They cannot prove that she was grossly negligent and that there was any way she could foresee that this would happen, as awful as it is, and we all stipulate it is. At this point in trial, I always have to sit down. This is how the court rules work. Prosecution gives a closing, I give a closing, they have an opportunity for rebuttal, and then I don't get to say anything else. And I'm sure you can see from my demeanor in trial, when the prosecution says something that I know I have an argument against, I get anxious, you can see a reaction, and I'm not gonna do that. But I am gonna tell you that as they argue, I will have many things that I wish I could get up and say, that's not true, and argue again. So what I would ask is that when you go back in the jury room and begin to deliberate, you think about and ask yourselves, what would Shannon Smith have said in response to the rebuttal where they get the last word? I would just ask that you consider that in your deliberations, because I guarantee you I'll have a very hard time sitting here knowing that the prosecution gets the last word when I know the defense would disagree with it. And I am asking each of you to vote that Mrs. Crumbley is not guilty because she is not guilty, and because a not guilty verdict is the only fair and just result in this case.
Thank you, Ms. Smith. Rebuttal?
Yes, briefly. We do get the last word. I get the last word. The people do, because it's our burden. And that's why we get the last word. And it's a burden I embrace. It's the burden to prove beyond a reasonable doubt that Jennifer Crumbley is guilty of involuntary manslaughter. It's not a burden that I have to prove every single fact about the case beyond a reasonable doubt. That's not the law. That's what she told you the law was. It's not the law. The law is I have to prove every element beyond a reasonable doubt. Beyond a reasonable doubt. Not any doubt. Beyond a reasonable doubt. The defense gets to decide how they present their case. They get to decide that. She gets to stand up and say what she said. But your job is to listen to the facts of the case. Your job is to listen to what the judge tells you the law is. Your job is to tell you to look at the evidence, the people sitting here, not what somebody else wants to have said that they said, but what they actually said. Your job is to consider not what lawyers say about their own life and their own circumstances and their opinion. Your job is to consider the facts and the evidence in this case. I have to address a couple things, and I'm going to be quick. There was absolutely no evidence at all presented to you that anybody at that meeting told Jennifer Crumbley it was no big deal. There was no evidence of that. There was no evidence at all that Jennifer Crumbley was very surprised by how long the meeting lasted. Jennifer Crumbley didn't say that. That's not into evidence. I don't have to prove, the people do not have to prove that Jennifer Crumbley knew that there was going to be a homicide or a school shooting. As Lieutenant Willis pointed out correctly, if she knew exactly what was going to happen, she'd be charged with murder, ladies and gentlemen. She is not. She is charged with involuntary manslaughter. And the elements, you'll get them, I read them to you. The standard and what I have to prove is not that she knew that her son would go shoot up a school and kill 4 kids. I have to prove that she had a legal duty. She negligently performed that legal duty. She negligently did not take steps to take care and protect the other children in that school when there was a reasonable foreseeability that ordinary care was required. The smallest of things. The smallest of things. I apologize to the law enforcement in this room and any listening that I have to stand here and to defend their integrity, but I do. Because if you believe that Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand here, including
What objection?
I'm objecting because I'm allowed to argue based on what's in evidence, and Ms. McDonald is trying to make me sound like I've done something wrong. And I didn't. My argument was proper.
She's arguing. It's my rule.
Overruled. You commented on the statements of the police officers. You argued about the statements of the police officers. She gets to argue about the statements.
The exact quote was, they probably did that to all the witnesses in the case. If you believe that, then you believe that the sheriff's office, Lieutenant Willis, Special Agent Brandon, the ATF, the federal marshals, the Detroit Police Department, anyone the evidence tech, they were all in some sort of conspiracy. That's what you have to believe, and I know that that's not what you're going to find. Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do. Nothing here was designed. Nothing here was made up. And I don't have to convince you of that because I know that you're going to use your hearts and your minds and your sense of reason, and you're going to look at the evidence. The first statement Jennifer Crumbley makes about this gun, her son's gun, was at the substation after the shooting, and this is what she said. It was hidden. It was hidden. That's what she said. It was hidden, ammunition separately. It was hidden in a dresser. It was hidden. That's all she said about it. The school's actions or inactions do not excuse the culpable behavior by defendant. Ladies and gentlemen, he literally drew a picture of what he was going to do. He drew a picture. It says, "Help me." It has the drawing of the gun that she bought him, posted, and bragged about. Blood everywhere. The thoughts won't stop. The world is dead. He drew her a picture. Pretty egregious and unique circumstances. And in fact, it is absolutely not true that we have to worry that we'll all be sitting here. We agree on one thing. Her testimony is evidence. Jennifer Crumbley's testimony is evidence, and you should consider it. And when you consider it, I'm confident that you will agree it is not consistent at all. It wasn't even consistent from her direct examination to her cross-examination. She acknowledged sitting here when Mr. Keese asked her about, "Where is this phone? You said you took the phone." You heard what she said. We took his gun away. We took his gun away. I don't have to prove flight beyond a reasonable doubt. I already told you that. You can infer consciousness of mind. And what does that mean? You run, you delete text messages, and you lie because you know she knew she did something wrong. The question about why Jennifer Crumbley didn't take one of these small actions, secure the gun, find out where the gun is, it looms large in this courtroom. There is no one it looms larger for than the victims and the family members of those kids who were killed on that day. We don't have to prove why. But remember what she said. I wouldn't change a thing. Just hours ago, she said, I wouldn't change a thing. This prosecution is about nothing else except the facts of this case and what Jennifer Crumbley did and what she didn't do. If only I could look at the faces of these parents who are dealing with unspeakable darkness and grief. If only I could make that better. I could appease them, as defense counsel suggests, by charging Jennifer Crumbley. These are the parents of Hannah St. Juliana. These are the parents of Madison Baldwin. These are the parents of Tate Meir. These are the parents of Justin Schilling. And not just their parents, they are mothers and they are fathers and they are sisters and their brothers. And do not think for 1 second that this prosecution takes any of that pain away, because it doesn't. This isn't an effort to appease anybody. Your verdict means one thing. It means Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter beyond a reasonable doubt. And I am not going to stand here and tell you that that's going to take away this pain that these families feel, because it will not. I won't stand here and say that the pain will be gone for Molly Darnell, or Christy Gibson Marshall, or Special Agent Brandon, who ran out of that office so quickly that his chair was spinning, or Ed Wogrowski, who viewed the surveillance video to identify the path of the shooter, and it was burned in his brain forever, or for Lieutenant Tim Willis, who answered the call to lead, and maybe the biggest ask of his entire career, but one he did not back away from. Don't render this verdict for the hundreds of kids in that school. It will not appease them. Nothing will. But you are now called upon. You are called upon. You are called upon to do your part as jurors, to keep the oath that you took, to be fair, to be honest, to be impartial. You are the ultimate fact finder. But what happened that day? You are the ultimate fact finder of the truth. We have met our burden. We have proven beyond a reasonable doubt that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter for failing to exercise ordinary care when the smallest, tragically simple thing could have prevented it. It could have saved Hannah. It could have saved Madison. It could have saved Tate. And it could have saved Justin. And she sat here and she said she wouldn't do one thing different. And lastly, I'm going to address the question I know that's on the minds of a lot of people in this courtroom and a lot of people listening. I'm going to say, but I know they're all asking, and they want to say, when she took the stand and she testified about her own loss, and she was asked the question, you lost everything. She said yes. She hasn't lost everything, ladies and gentlemen. Her son is still alive. Find her guilty of 4 counts of involuntary manslaughter. Thank you.
Thank you. I have to have you come back Monday. But you know that, right? You knew that before I said it. You guys have been so terrific. You've been on time. I have not heard, I still have 5 alternates, right? Because no one, as far as I know, has violated any rule, has read a newspaper, has posted anything on Facebook, has talked to anyone who talked to someone else who repeated it to the court. We appreciate that. We know how hard it is. I'm going to ask you to come back Monday. But I want to instruct you that during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth. The lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media. Do not post on Facebook. Do not read Facebook. Do not do research. Do not discuss the case with anyone. I'm going to ask you to come back on Monday. You'll all come into the courtroom. Can you come back at 9 o'clock on Monday? I'm going to give you instructions. After I give you the instructions, 5 of you will be drawn by lot, but you will still be sequestered in a separate jury room. So you will still be required to be here. All right, do you have any questions about the schedule? Did you all order lunch for Monday? All right, no questions about the schedule. We have come this far. Please follow my instructions. It's very important to both sides. We appreciate you. Have a good weekend and stay healthy, all right?
All rise for the jury.
I'm gonna let the jury go, okay? You can be seated. I'm gonna let the jury go, so we'll wait. I'm gonna have, I think I said this before, I'm going to have all the jurors come back on Monday morning. The captain graciously volunteered to have deputies here late into the evening, but it is late enough that that would be very difficult. So at 9 o'clock on Monday morning, I'm going to instruct the jury. I'm going to have the 12 jurors deliberate, but I'm also going to sequester the 5 alternates. All right, any questions about that procedure?
No, thank you, Judge.
No, Judge.
Thank you. So can you wait till the jury's gone?
Wait till I hear something.
Okay. All right, yeah. I'm gonna check, so thank you. Have a good weekend.
Thanks for having me.
Okay, whenever you want, I just want to read this. I have all these. Okay.